But may I have your lordship's kind leave to mention a matter of extreme urgency? There's a tender clause that we've challenged. The tender last date for submission of the bids is 27th. Tender clause says that only parties in West Bengal can participate, whereas the same authority has granted me two tenders, one in 18, one in 20. This time they've come up with the clause restricting the scope of participation only to parties in West Bengal. So we've assailed this, saying that this curtails my right of participation and it doesn't give me a level playing field. It's a solitary challenge. I'll just rely on one decision, my lord. Kindly allows it to appear on Monday. It's ready to be filed. I'll just file and give the number to your lordship's officer. Kindly allows it to appear on Monday, my lord. 27th is the last date for submission of the technical bids. They hold a pre-bid meeting. In the last minute, they say the clause can't be changed.
26th, Tuesday.
26th. Grateful, my lord. Very, very grateful.
My lord, may I mention one urgent application before your lordship, my lord? Here also, my lord, I'm challenging the order of blacklisting, my lord. My lord, the urgency is this, my lord. Now our new tender has been floated, my lord, and last date of submissions of a bid document is 2nd December. My lord, a day may be fixed, my lord, so that I can come back. Only one thing, my lord, I made a party, my lord, there's a, my lord, authority of Punjab and Haryana. So, my lord, time. Thursday, 28th. Yes, ma'am.
May I be
Grateful,
permitted
my
to mention, my lord? My lord, there is a violation of the order dated 22/8/2022, where illegal construction is going on and the petitioner is being aggrieved for this illegal construction. So I'm mentioning for inclusion in the list, my lord.
Please come on 2nd of December.
Grateful, my lord.
My lord, may I be permitted to mention one matter? This matter has been listed as item number 1992 in the combined monthlies before your lordship. My lord, this is a 2022 matter, my lord. The matter has not been heard till date, my lord. My lord, the ground of urgency is that, my lord, the respondent bank.
Please come on 2nd.
Be privileged.
Yes.
I've got a missing original side.
Original side, please wait. Yes.
Original side, my lord.
Yes. What is it? Please say.
Lordship, may I be please permitted to mention one matter? Lordship, I am from the petitioner's side, where I am the legally wedded wife of respondent number 15, and the respondent.
What you want? Please tell me.
My lord, the matter is in the monthly list of November as 1399, like 1399. So I would request you to, if it can be heard on an urgent basis in the next week.
Next week it's not possible. Come on 2nd. Mention.
Sure, my lord. Thank you so much. Grateful.
Yes, madam.
My lord, may be permitted to mention this matter, your lordship. This was running as item number 1921 in combined monthly list of November. My lord mentioned it earlier. Lordship was pleased to, because pleadings completed, your lordship ready for hearing. So your lordship directed that the matter may be released, and it was to appear as to be mentioned on 18th of November. But my lord, the difficulty is, my lord, the file cannot be traced. My lord, I have tried to follow with the lordship's court officers and the peons, and they're directed.
The matter is there in the list and the file cannot be traced.
No, your lordship.
You ever?
The notice, your lordship. Mr. Chatterjee was appearing, my lord.
Whoever it is, let the file be traced first.
Your lordship.
Lordship, may I be permitted to mention one adjourn motion? Last occasion.
Adjourn motion.
Yes, sir.
What is adjourn motion?
Adjourn motion.
Yes, what is it?
It was a matter of medical negligence. Last time, your lordship has been heard of, and there was a direction to serve the affidavit in opposition on behalf of the respondent. And the matter was supposed to be come into the list after 4 weeks, but yet it has not been listed, lordship.
Not been listed. Please mention on the 2nd. Yes.
Lordship, may I be permitted to mention one matter for non-prosecution, Lordship?
Yes, give.
Lordship.
My lord, may I be permitted to mention a matter for upgradation, my lord?
Come on 2nd. Yes, original side.
Last day, my lord, I noticed your lordship on the ground of company secretary, Mr. Ray moved the petition. Mr. Ray, my lord, submitted that in 2014 it was amended the penal provision. But just I want to hand over the old Companies Act, where it provides from 1988, if the product capital below 25, it was mandatory to appoint company secretary. I put for notice. May I just hand over the book, Lord, or may it appear to be mentioned?
Yes, it has to appear as to be mentioned. Otherwise, because your other side is not here.
My lord.
Give notice, it will appear as to be mentioned. সামনে সপ্তাহে
Lord, on
একটা
Tuesday,
কিছু
my
date
lord.
দিয়ে দিন। CAV করা আছে তো। To be mentioned এ রেখে দিন। Tuesday?
Lord, Tuesday, my lord.
Tuesday.
My lord.
My lord, may I be permitted to mention a matter for release, my lord? It has been wrongly filed in group 9. It was supposed to be filed in group 6. So
Where is the item? Where is the item?
item number is not in running in the list, your lordship.
Not running in the list. The file is here.
Yes, your lordship, the file is here.
Where you will give the number for release.
My lord, I was praying for your lordship's leave for drawing up of a judgment and order dated 11th November passed by your lordship, my lord. 7 days has passed, my lord. Therefore, my lord, your lordship will, my lord, kindly grants me leave, my lord.
Where you will give.
Lordship, some LIC matter where, my lord, I am the petitioner, my lord. Same cell cause of action 3 matter is running in the current daily list, my lord. Item number 395, 96, 97, my lord. I am praying there is a matter, my lord, where our division bench already passed favorable order to me. My lord, same cause of action will kindly give some accommodation to her the matter,
Please come on 2nd of December.
lordship. God bless you.
May I make a appellate side mentioning?
The appellate said mentioning your work. Please come on 2nd December. Call the list, please.
Item number 1.
Lord, I appear on behalf of the petitioner, my lord. Lord, this is concerning a scheme.
But I am appearing for WBITC. Have newly been briefed. Malad, kindly, there was a direction to file affidavits.
Lord, that
But-
was
3rd of May
But I know,
2024.
Malad, I am late.
Time has expired.
Kindly give me 10 days time. I'll file. WBITC will file itself because affidavit is required. But there are disputed facts.
Is any other party required to file the opposition or
my lord,
WB?
WPID said the
should be-
state should be because the commercial department tax their viewpoint because they are the one who is supposed to give
Let me
certificate.
see the file once. Are
My
the
lord, this is
taxing
the second
authorities?
time this matter has been come up, my lord. My lord, on earlier occasion, the state have been duly represented and your lordship will find the same. My lord, on page number 164 and 168 also, in volume 2 of my writ petition.
Listen, the state is a party, then the director of industries, WBIDC, and the tax,
Department of Commercial Tax.
right? Your learned friend will be there for the respondent numbers 1 to 4.
WBITC.
Only
WPID.
WB.
Yes.
Then 3 and 4. And you want the
My lord, so
Commission
far
on
as
Commercial
six is
Taxes. Who
concerned,
will appear?
my lord, the state
Who is
ID,
going-
State.
state
Who
government.
is going to appear? Did you serve notice? See, I do not see the appearance of the state.
In this matter, Malad, state has not appeared, subject to
My
correction.
lord, not appeared, my lord, but the earlier occasion on 3rd
Earlier,
of May, my lord,
in this writ petition, no.
in this writ petition, my lord, 3rd of May 2024, notice have been served, my lord, and the affidavit of service is already on record.
Very well, but then you serve one more notice so that in their
My
absence,
lord, in
the
that
matter
event, kindly grant me liberty to serve before the GP's office, my lord. Since it's original side matter, I
AOR's office you
AOR's
serve.
office, my lord, Mr. Sinha's office. My lord, may I seek for one indulgence, my lord, if this can be a peremptory direction and it will be a time-bound manner, my lord.
But I said not. No, please state it.
Well,
But
the
he is
state
appealing
is
for
here,
all the parties. But kindly extend the time, then we'll file our.
Are you aware that there is a direction? What happened? Please come. Time to file the affidavit in opposition has expired long back. Stop. On the prayer of the learned advocates representing the respondents, time to file the affidavit in opposition is extended peremptorily till 18th of December. Reply, if any, 1 week after reopening of the court after the Christmas vacation. Liberty to mention the matter for
My lord, kindly
hearing.
fix it, my lord. This concerning a huge sum of money which is pending for quite some time now.
Mention after the oppositions are over, it can be listed.
Great.
Lord, I have the instruction to appear on behalf of the contemner. Let my learned friend serve me a copy of the contempt application. I'll take instruction.
Without serving a copy upon the contemner.
But so far as contempt petition is concerned, subject to correction, they file.
unless your lordship takes cognizance of the contempt, the question of filing doesn't come. But since my clients have gone through the list, they have told me that enter appearance,
Very well, please
take a
come.
copy.
Yes, Your Lordship. The petitioner complains of violation of the direction passed in the order dated 3rd October 2023, corrected video order dated 17th November 2023. আপনি লিখুন read with, not corrected. Read with the order dated. Stipulate copy of the contempt application be served on the alleged contemners with an additional copy to Mr. Bishwajit Mukherjee, learned advocate, who is present in court representing the alleged contemners. Stop. The contempt application is made returnable on 18th of December. Stop. An affidavit of compliance shall be filed on the adjourned date.
Grateful, ma'am.
Lord, may I just pray for today's time? Lord, I haven't been able to sit with the client after the report.
Not today.
Just today. So great.
But there was a direction that upon the Milord authorities to cause an inspection and file a report.
Was the inspection conducted?
Milord, inspection was done, but Milord, a commotion was created, Milord. I'm told by the client, Milord, though my client is in hospital after that inspection due to pancreatitis problem. He called me from the hospital that there was a commotion and inspection was held. But outcome, Milord, I don't know. But Milord, I have asked my client to, because my Lord's specific query was whether there was any other distribution box available, Milord, in front of the premises. Milord, he has taken a photograph. Milord, this is the existing distribution box with the number, Milord, is there. AC 4023. Milord, just 100, not even 100 feet. Milord, from that, usually the premises, Milord, used to get connection. This premises, which is now, Milord, having a new connection, Milord, was having earlier connection, Milord, from this box. And Milord, my petitioner's premises also having connection from this box. There are boxes, distribution boxes on the SM Banerjee Road. So, Milord, this is one of the box which is nearer to the premises. But Milord, I don't know the report which will come from them, the authorities.
Nobody is here today. I'll make it not today. You give a notice.
Lordship, Mr. Devanjan Mukherjee appearing on behalf of CSC as per instruction from our Lordship praying for short Passover.
Passover is not possible. I'll make it only not today. Tell him to bring the report on the last day. Take back your photograph.
Much obliged.
My Lord, I'm for the petitioner. My Lord, may I file my affidavit as to service, my Lord? My Lord,
State of Jharkhand.
yes, my Lord. My Lord, what has happened, my Lord, in this matter, my Lord? My Lord, I have a bank account, my Lord, in HDFC Bank, my Lord, in the HDFC Bank, my Lord, in the Dalhousie, my Lord. I have a branch, my Lord. I am maintaining my current account there, my Lord. My Lord, what has happened on 4th of October, my Lord? I got an intimation from the HDFC Bank that my account has, a lien has been created over my account. My Lord, I've asked the HDFC Bank why the lien has been created, my Lord. They have not informed me. My Lord, on 15th of October, my Lord, the entire, my Lord, my bank, account, my Lord, got freezed, my Lord, got the debit freezed, my Lord. Then I've intimated to the bank, my Lord, because this is only my current account where I operate my business. My Lord, they have informed that there is some intimation which they have received from respondent number 1 and 2, my Lord, from Jharkhand. In regard to, my Lord, any dispute which has happened at Jharkhand, my Lord. I have visited there in the Jharkhand, my Lord. I got to know that there are some transfer of amount to my customer, and that customer has paid some amount to me, my Lord. So that's why the lien has been created over that account. And thereafter, my Lord, a debit freeze has been happened, my Lord. I cannot operate my account, my Lord. My entire business is being stalled, my Lord.
So your entire cause of action arises in Jharkhand. Why are you here?
My lord, everything has happened here, my lord. My lord, I have received the payment here, my lord. My business is here, my lord. From whom I have received the payment, he has also have a business here, and I have delivered all my products from here only, my lord.
And you did not impede the police authorities, officer in charge of Jharkhand.
My lord, what has happened, my lord? Respondent number 2, my lord, who was previously dealing with this matter. Then when I have got the information from the respondent number 2, they have said that the matter has been transferred to CID. Then, my lord, I went to CID, my lord, I visited them, my lord, I have asked them. They told me to deposit all the relevant informations, which I have deposited to them. They said that you deposited all the facts and with all the relevant documents. I have done over there, my lord. But till, my lord, they have neither, my lord, they have defreezed my account or the lien has not been removed from my account. My lord. I have given all the intimations to them. I have given all the documents to them, my lord. I have annexed my letter, my lord, with all the documents, my lord, which I have submitted to them.
And who is the respondent number 4?
My lord, respondent number 4, my lord, he's the party, my lord, from whom I got the payment.
So he is your party. Respondent number 5?
My lord, respondent number 5, my lord, he is another my sister concern, my lord. The next item, my lord, has been filed by him only because I have transferred some amount to him. So when I have transferred some amount to him, his account has also got freeze.
Yes. But then, I don't know, let me see your service.
My lord, my lord. My lord, bank has refused to take that, my lord, which I got the intimations from the track delivery report as well as from my lord. I have received the consignment back, my lord, with an endorsement received by the bank. And in regard to my lord 1 and 2, my lord, it has not been served, my lord.
Not been served.
Not been served, my lord.
Serve, please come. None appears on behalf of the respondents.
My lord, in that case, my lord, may I indulge?
Let fresh service be effected. A list on 3rd of December. See if anything
In
can
that
be
case, my
done.
lord, may I pray, my lord, one thing, my lord. Let the lien be created over my account, my lord. Let the debit freeze maybe removed, so that, my lord, I can operate my account.
No,
Whatever
no.
the amount is there, my let it be like that, my lord.
Because there may be certain transactions from your account which are illegal. Online frauds are going on. I'm getting so many matters over here.
My lord, in this case, my lord, if you see,
Either ED or CID, somebody or the other is there.
but
None of the parties of the state is a party over in your writ petition. I don't know whether the Jharkhand authorities will come or not. So let's see what happens. Same order in item number 6. ওনার যেটাতে পরে কথা বলবেন লিস্ট আকুন
তুমি মেনশন কেন এসছে?
As your lordship is aware, the National Company Law Tribunal functions out of at present out of a heritage building which is situated on the rear side of the town hall. So the town hall extends from the main road. This is towards the rear side of the town hall. The income tax building is housed between the income tax building and the main road. Now, because it is situated at a very short distance from the High Court, it was convenient for all the stakeholders concerned to attend to the NCLT as well as because the entire setup is around this area. Now, before I proceed further, it is perhaps necessary to just invite your lordship's kind attention to the fact that the NCLT primarily deals with two branches of law. One is the Companies Act, and the other is the Insolvency Law. Now, as your lordship is aware, that Companies Act was wholly a limb and branch of our High Court. And we had a separate company jurisdiction, and the Companies Act till the Company Law Board was formed sometime in the year 2012. There certain jurisdictions, certain applications went to the Company Law Board. But even today, the High Court retains a company law jurisdiction. And even today, a large number of company law matters relating to winding up are receiving the consideration of your lordships in the High Court. In other words, what I'm trying to say is that the company law jurisdiction was always a limb of the Calcutta High Court or of any other High Court. And under the Companies Act of 1956, which was in force till December 2016, all company law matters were decided here. Therefore, the branch of company law has been exclusively dealt with always, at least from the from 1913, which is the original Companies Act, by the High Court. So, it is the High Court lawyers who have primarily always dealt with this particular branch of law, litigation, and legislation. Now, when the Companies Act 2016 came, it was also the birth. It's Companies Act 2013, but notified in 2016. So really, the matters went to the company, to the NCLT in 2016. The NCLT started functioning from 2016 in December, and started dealing with company law matters and insolvency matters. Now, from 2016 till today, the NCLT has been functioning out of this particular building. Completely unknown to any of the stakeholders, which include litigants, lawyers, clerical staff, office staff of the NCLT, completely unknown to everybody else. An alternative corporate bhavan has come up in Rajarhat, which is at a distance of about 17 kilometers from the Bishwa Bangla gate. So, it takes about 1.5 hours from the High Court to reach over there. And the proposal is to shift all the departments dealing in corporate affairs, such as the liquidator's office. The liquidator's office till today is attached to the Calcutta High Court. And it has its offices in 9 Old Post Office Street, just across the street. So, the office of the liquidator, the office of the regional director, the office of the ROC, the office of the Special Investigation Fraud Office, these are all going to go there. And along with that, the NCLT will also go, as if the NCLT is a limb of the Department of Corporate Affairs. And this is where our basic objection lies. my lord, the NCLT, my lord, is, my lord, a completely separate juristic entity constituted under a separate set of laws. Now, my lord, the NCLT is virtually being treated by, my lord, the Ministry of Corporate Affairs and, my lord, the Ministry of Finance to be, my lord, a part of its office. And, my lord, I will start, my lord, by first inviting your lordship's kind attention to the affidavit in opposition which has been filed, where, my lord, the principal, my lord, argument, my lord, of the my lord, government appears to be that we need a particular department which will house all our officers together, so that there is better, because, my lord, the officers, my lord, of the corporate affairs ministry are often required, my lord, to attend to the court. So, my lord, by that logic, my lord, the Navanna should, my lord, have a branch office, my lord, in the High Court premises, because, my lord, very often, my lord, the entire writ jurisdiction, the government has to answer to it. So, my lord, while I can understand that the Ministry of Corporate Affairs, my lord, wants to have all their offices in one building, that's their policy decision. But, my lord, the moment they want to tag it to, my lord, the court, which is, my lord, dealing, my lord, in company law and, my lord, in insolvency, then, my lord, there is an attempt to, my lord, confuse the identities, my lord, of the legislature, my lord, with the court. And that is, my lord, completely contrary to the doctrine of separation of powers, my lord, which we will seek to address your lordship on. Now, my lord, kindly, my lord, permit me.
Is also another one, access to justice.
Now, my lord,
এদিকে চলে আয় না, এদিকে চলে আয়,
now, my lord, kindly, my lord, first, for a moment, just have the petition. My lord, kindly permit me, my lord, to show your lordship, my lord, one or two. My lord, annexures, my lord, in the petition. My lord, kindly have my lord, page 37 of the petition. এটা দেখিনি notification here. My lord, your lordship will find, my lord, at page 37. This is, my lord, the notification of 1st June 2016. And here, my lord, your lordship will find that, my lord, the National Company Law Tribunal benches, my lord, are constituted. And, my lord, at serial number 9, page 38, my lord, your lordship will find that the NCLT Kolkata bench, my lord, has jurisdiction over the state of Bihar, Jharkhand, Orissa, West Bengal, and, my lord, Andaman and Nicobar Islands. So, my lord, quite a broad and, my lord, of course, my lord, Orissa has, my lord, now since, my lord, developed its own NCLT. Then, my lord, kindly, my lord, have, my lord, page 41, where, my lord, we have tried to, my lord, give, my lord, your lordship, my lord, the present location of the NCLT, my lord. This is, my lord, the Google map, my lord. It is, my lord, at, my lord, the Shahpurji bus stand, near the Shahpurji bus stand. But, my lord, your lordship will see, my lord, it is, my lord, I am told, my lord, virtually in no man's land. So, my lord, my lord, a better, my lord, description, my lord. Yeah, I'll just let me place this. My lord, page 42, my lord, is another map, my lord, where we have said, my lord, according, my lord, to Google Maps, my lord, it is 41 minutes by car, my lord, from the Bidhan Nagar railway station. It's about 1.5 hours, my lord, from the High Court area. There is, my lord, no metro rail connectivity, bus service, nothing.
So this is their access to justice.
My lord, page 44 is the distance, my lord, from the Sialda railway station, my lord, everything, my lord, by bus. Even if you have your own car, my lord, it's about an hour. So, my lord, one of the principal questions, my lord, which we will be raising for your lordship's kind consideration, my lord, is the access to justice as well. My lord, not everybody, my lord, is privileged to have, my lord, a car. So, my lord, there must be, my lord, ways and means of, my lord, accessing the place. Kindly now, my lord, have, my lord, the photographs, my lord, which, my lord, start, my lord, from page 46.
There is no infrastructure around this area.
Bolchi. Page 46, my lord, your lordship will see, my lord, the photograph, my lord, of a fairly modern building. It's nice to look at. But, my lord, from page 47 onwards, your lordship will see, my lord, it is completely vacant, my lord.
In the middle of nowhere.
My lord, I'm sorry, my lord, we have given your lordship some black and white photographs. We have
No,
seen
no, I have the colored ones.
colored photographs. I'm sorry. Now, my lord, from page 47 onwards, your lordship will see, my lord, completely barren land all around. My lord, some of us have visited the premises. There is nothing in the vicinity. So, my lord, it is, my lord, I am told, my lord, a rather impressive structure in the middle of nowhere.
Every NCLT in this country is located in the central part of the city where adequate infrastructure is there for all litigants to access, including lawyers.
Now, my lord, NCLTs, my lord, since 2016, my lord, there are 13 NCLTs, my lord, in India. And, my lord, I think except with the exception of the Hyderabad NCLT, they're all situated, my lord, at a distance of about 1 or 2 kilometers, my lord, from, my lord, the High Court. Of course, my lord, my friend, my lord, will tell your lordship better on this. Now, my lord, having shown your lordship, my lord, the remoteness of the place, and therefore, my lord, if they, my lord, set up a court in a place, my lord, where, my lord, neither the litigants can go there, my lord, nor the lawyers can go there, my lord, I wonder, my lord, who the court will function with. Now, my lord, when I had initially moved the petition, my lord, an interim order was passed by my Lady Justice Bhattacharya, my lord, to the effect that, my lord, the visual service, my lord, the video, my lord, link, my lord, should function properly, and the, my lord, government was directed to ensure that. Now, my lord, with the utmost of respect, to say, my lord, that, my lord, the video, my lord, hearing will completely, my lord, substitute, my lord, the physical appearance. My lord, in that case, my lord, we could have all carried on, my lord, the High Court itself, my lord, could have, my lord, been carried out, my lord, from, my lord, the respective residential homes, my lord, of the learned judges. But, my lord, that is perhaps not, my lord, the intention. My lord, the access to justice, my lord, must, my lord, if somebody wants to appear physically, somebody wants to appear and address the court physically, then they must, my lord, have, my lord, adequate facility to do so. Now, my lord, I'll come to, my lord, the interim orders, my lord, that have been passed in the matter. But, my lord, I just want to point out that, my lord, we had made an elaborate representation to the government, my lord, at page 52. My lord, this is before we filed the writ petition, my lord. We've thought it prudent, my lord, to flag all the aspects, my lord, for the consideration, my lord, of the government. Now, my lord, having indicated this much to your lordship, my lord, kindly permit me to invite your lordship's attention to, my lord, the affidavit in opposition filed, my lord, by the government, my lord. This is, my lord, an affidavit affirmed by reply. No, I've got it. Now, this affidavit, my lord, affirmed by Mr. Reddy. My lord, kindly, my lord, have it, my lord, from paragraph 1 onwards at page 3. Kindly see, my lord, I am the joint director in the office of the regional director, Eastern Region, Nizam Palace. Now, my lord, the reason why I'm inviting your lordship's attention to paragraph 1, my lord, of the affidavit in opposition is that, my lord, the deponent, who is the joint director, is, my lord, attached to the Ministry of Corporate Affairs. And, my lord, I'll show your lordship 2 judgments of the Supreme Court, where the Supreme Court says that there is a dire necessity to separate, my lord, to bring all courts, my lord, under the Ministry of Law and under the Ministry of Law. All courts must function only under the Ministry of Law. And the sponsoring ministry or the parent ministry must, my lord, be separated, my lord, from the my lord, legal aspect of that, and there should be no And my lord, there should be, my lord, no, my lord, intermingling of this. In other words, there must be a complete separation. Because, my lord, once, my lord, a court is formed, then, my lord, it can't be allowed to, my lord, function under the, my lord, dictates, my lord, and, my lord, the instructions, my lord, of the ministry. So, my lord, my endeavor, my lord, is to point out to your lordship that the affidavit itself is, my lord, affirmed by, my lord, an officer, my lord, of the Ministry of Corporate Affairs. Now, my lord, kindly see paragraph 3. My lord, they say, my lord, in the 4th line at paragraph 3, that, my lord, this is a decision of the competent authority and is a matter of public policy. And they further say, my lord, in the last line of paragraph 3, that there is no fundamental right to work at a particular location. Agreed. There is no fundamental right to work at a particular location. But, my lord, there is a fundamental right for access to justice. And, my lord, that is, my lord, intricately connected with the system of administration of justice. And, my lord, it would perhaps, my lord, be, my lord, an absurdity to say that the administration of justice can take place, dehotes the lawyers. We don't need the lawyers. We can't go bad luck. So, my lord, when my learned friends in their affidavit in writing take a stand that it is against public policy, then, my lord, I would venture to submit that the public policy is in our favor. The public policy has to be, my lord, the courts, the administration of justice is all for the public. Therefore, you have to make it accessible to the public. Now, my lord, they also say the decision of the competent authority. Now, my lord, what is this decision? I don't know who has taken this decision. My lord, the decision to shift the NCLT from, my lord, within 200 meters of the High Court to, my lord, about, my lord, 35 kilometers from the High Court. This decision, my lord, who it has been taken, who has taken this decision, which ministry has taken this decision, we are, my lord, not privy to this information. I'm sorry, my lord, it's about 26 kilometers, not 35. 26 kilometers. So, my lord, this decision, my lord, of the competent authority, my lord, is a closely guarded secret to which, my lord, we are, my lord, not, my lord, parties. Now, my lord, your lordship will see paragraph 4. The decision to shift the National Company Law Tribunal is reasonable, fair, and has been taken into consideration the overall public interest. My lord, this is, my lord, nice literature and fanciful to, my lord, read. But, my lord, it is completely contrary to public interest. My lord, the public interest, and I'll show your lordship hereafter, appears, my lord, to be the convenience of these, my lord, officers who, my lord, will find it convenient to attend court. Thereafter, my lord, kindly, my lord, have, my lord, paragraph 5I at page 4, and kindly permit me, my lord, to read this slowly. Because, my lord, this exposes the entire philosophy between, my lord, this inconvenience that they want to cause, my lord, to all concerned. This is, my lord, the justification. I respectfully submit that the proposed corporate bhavan, so, my lord, they are now calling the court a corporate bhavan, which is a limb of their ministry. So, my lord, when we file, my lord, applications, my lord, under 251 or, my lord, under, my lord, section 95 and all the other, my lord. So, my lord, the central government doesn't have to do anything. Anything, my lord. So, my lord, the government, my lord, will, my lord, merely just treat this, my lord, as the NCLT as a limb of its office. So, the NCLT, my lord, in other words, should be a rubber stamp. We'll go there and we'll present the documents. So, it's a part of my office structure. Therefore, my lord, paragraph 4, subparagraph I, page 4, paragraph I, page 5, no, 4.
No, paragraph 5I.
Paragraph 5I, I respectfully submit that the proposed corporate bhavan has been built for having offices of several departments under the Ministry of Corporate Affairs under one roof for the convenience of all stakeholders. Permit me to pause, my lord. I have no problem with this. Having the offices of several departments of the Ministry of Corporate Affairs under one roof, please go do so, by all means. But, my lord, the court is not, my lord, a part and parcel of the Ministry of Corporate Affairs. So, my lord, if you want to have all the offices of several departments of the Ministry of Corporate Affairs, please do so. But the court, my lord, the NCLT is not, my lord, a department of the Ministry of Corporate Affairs. For better administration and working of the offices under the Ministry of Corporate Affairs. So, my lord, they will regulate the manner in which the NCLT, my lord, will carry on its office as if, my lord, the NCLT is under them. Some of the offices which would be functioning from the corporate bhavan are the offices of the Regional Director, Northeastern Region, Registrar of Companies, West Bengal, Official Liquidator, High Court, Calcutta. So he'll also have to shift his office from here and go there. Therefore, if your lordships require him in the company jurisdiction, and my lord, your lordship is aware, whenever, my lord, the company bench, my lord, takes it up, my lord, the official liquidator is, it's a duty incumbent on him to be present here. Including, my lord, the office of the Official Liquidator, High Court, Calcutta.
Serious fraud.
Then, my lord, Serious Fraud Investigation Office. These will, my lord, all have to go. The officials of the said departments have to work in coordination with each other and also attend the National Company Law Tribunal with records on a daily basis. And if the offices of the aforesaid departments are situated at a distance of each other, coordination and logistics consumers, my lord, I have no problem. Let their offices all be clubbed together. But, my lord, the moment they say, my lord, that, my lord, the NCLT is also one of their departments, then, my lord, is where, my lord, the problem arises. Now,
paragraph 8 I think it will connect.
my lord, now, my lord, kindly, my lord, have,
Page 8
my lord, page 8 of the reply. I was, my lord, inviting your lordship's attention to page 4. Kindly, my lord, have page 8 from the top.
C is a key ministry.
Kindly see, my lord, the first from the top. I further deny and dispute that the petitioners are affected by the decision to shift the venue of the learned tribunal from Esplanade to Newtown. Further, it is stated that the Ministry of Corporate Affairs, hereafter referred to as MCA, is a service-oriented ministry catering to the needs of the public in general and the corporate sector in particular. The MCA is a key ministry acting as a bridge between the government and the corporate sector and is responsible for maintaining close and continuing dialogue between the government and the management process of the corporate sector, providing facilitation and service of best possible standards under one roof to business and companies. My lord, they want to, my lord, improve, my lord, the infrastructure of the registrar of companies, make it more accessible. They want to improve the infrastructure, my lord, of the regional director of companies, make it more accessible, my lord. They can do so by all means. But, my lord, I do not understand, my lord. Your lordship will see the entire tenor of the reply is as if, my lord, the National Company Law Tribunal is, my lord, a part and parcel of their office premises. And therefore, my lord, they need to have it all in one building.
Last, in order to achieve.
My lord, remaining at the same page, which is paragraph 8, page 8,
Last,
my lord,
in
last
order
5
to-
lines from the top.
in order to in order to
Ah.
achieve the
These
objective.
offices are located, my lord, 5th line from the bottom of page 8. These offices are located at different places in Kolkata, resulting in lack of coordination on the one hand and inconvenience to stakeholders on the other. Besides being a burden on the exchequer, in order to achieve the objective and giving the present operational difficulties in running these offices from different areas, the competent authority has decided to construct a corporate bhavan building in Kolkata, which would house the offices of the regional director, registrar of companies, official liquidator, High Court, Kolkata, branch offices so and so,
Including
branch offices so and so of SFO under the Ministry of Corporate Affairs.
including NCLT.
Yes. Now, my lord, kindly see, including NCLT.
Under the Ministry of Corporate Affairs.
Including, my lord, my lord, authority has decided to construct a corporate bhavan building in Kolkata, which would house the offices of the regional director, registrar of companies, West Bengal, official liquidator, High Court, Calcutta, branch of SFIO, including the Kolkata bench under the Ministry of Corporate Affairs.
Which is a complete violation of the Supreme Court order.
The independence.
My lord, the independence of the judiciary has, my lord, been my lord, treated to be, my lord, their fiefdom.
Because in 60% of the proceeding, the departments are the other side.
The Ministry of Corporate Affairs to function from one place for administrative convenience. So, my lord, they will administer the working and the functioning of the NCLT. My lord, this is so jarring that, my lord, it would be like saying, my lord, that, my lord, all the departments of the government, my lord, should be here. Because, my lord, the High Court functions under their instructions. So, there will be better coordination. The High Court is also will become, my lord, a part of the government office. And, my lord, and pass orders are, and, my lord, kindly, my lord, if this is what they are going on oath to state in the affidavit, my lord, there will be a complete attempt on the part of the department, my lord, to influence, my lord, the judiciary. Same office, same building. And they are saying this on oath that this is my department. You're not a court. You're not a court. You're an extension of my department. Therefore, I want to bring about cohesion amongst all my departments.
This is against the
Now, my lord,
structure of the constitution.
my lord, separation, my lord, of powers. My lord, we'll take your lordship to, my lord, Article 50 of the Constitution, the independence of the judiciary. This is, my lord, the basic structure of the Constitution. You cannot, my lord, seek to tamper with it or tinker around with it. Now, my lord, kindly see, my lord, just after, my lord, the portion that I read, such a practice in various cities like Chennai, Ahmedabad, Hyderabad, etc., accordingly felt if MCA was allotted 2 acres of land in any good location in Kolkata, problems faced by the ministry at the time would be mitigated to a large extent. This will not only result in improving overall functional efficiency of the ministry as a whole, but would also provide various facilities under one roof to the stakeholders.
Ministry, functional efficiency of ministry. So this does not concern the public.
So, my lord, as my lord, Mr. Bose is pointing out, my lord, this will not only result in the overall functional efficiency of the ministry, my lord, by all means. My lord, let them take all their departments, my lord. One, collect them, my lord, from Nizam Bhavan, Nizam Palace. Collect them, my lord, from, my lord, Esplanade, 9 Old Post Office Street. Let them put it all in one place. We have no problem with that. But, my lord, they cannot, my lord, confuse, my lord, the powers of the executive with the powers of the judiciary. Now, my lord, pausing here for a moment, my lord, kindly see, my lord, that this is, my lord, in complete, my lord, contrast distinction, my lord, of the views, my lord, of the Honorable Supreme Court. Swiss reverse. No, this is 2010. Okay.
This was the Madras which was followed in Swiss reverse.
My lord, may I first, my lord, rely upon 2010, volume 11, SCC, page 1, which is, my lord, the Madras Bar Association case.
No. NCLT.
My lord,
What was the
Thou?
point raised?
It is thou.
Page. Bench ko
Bench take debe na.
bench.
No, this is marked copy.
This is mine. No, I don't think so.
My lord, may I?
Well, we have another copy. Kindly.
My lord, may I, my lord, hand up, my lord, this.
You are working on this.
Okay.
2010, 11.
It was what was
2010, volume 11, SCC, page 1.
What was challenge was the constitution of NCLT and NCLAT.
My lord, kindly have this judgment, which, my lord, the judgment, my lord, really begins, my lord, at page
18 to 19.
Page, my lord, 18. The judgment begins from page 18, my lord. And kindly permit me, my lord, to take your lordship to.
This was challenging the constitution of
My lord.
NCLT and NCLAT.
My lord, paragraph 1, my lord, of this judgment. Kindly see, my lord, at page 18. These appeals arise from the order dated so and so of the Madras High Court challenging the constitutional validity of the Companies Act 1956, so and so, providing for the constitution of NCLT and the National Company Law Tribunal, NCLAT. So, my lord, this was, my lord, the challenge. Now, my lord, kindly have paragraph 2. In the said writ petition, the Madras Bar Association raised the following contentions. Kindly, my lord, have II, Roman 2. The constitution of the National Company Law Tribunal and the transferring of the entire company jurisdiction of the High Court to the tribunal, which is not under the control of the judiciary, is violative of the doctrine of separation of powers and the independence of the judiciary, which are parts of the basic structure of the Constitution. So, my lord, this was, my lord, the issue, my lord, which was flagged by the Madras Bar. Kindly, my lord, now have
120 paragraph regulation.
46. Again, 46.
It's
40.
showing independence of judiciary
Huh.
and separation of powers. No? It
Convenience
is
of
at
ministry.
46.
The paragraph তুমি যেটা পড়লে, so that is absolutely inconsistent.
So, my lord, this was the issue, my lord, that, my lord, was flagged, my lord, by the Madras Bar. Kindly, my lord, now have, my lord, page 35 of the report. And, my lord, kindly take paragraph 46. Kindly see, my lord, the heading, independence of the judiciary. Impartiality, independence, fairness, and reasonableness in decision making are hallmarks of the judiciary. If impartiality is the soul of the judiciary, independence is the lifeblood of the judiciary. Without independence, impartiality cannot thrive. Independence is not the freedom for the judges to do what they like. It is independence of judicial thought. It is the freedom from interference and pressure which provides the judicial atmosphere where he can work with absolute commitment to the cause of justice and constitutional values. It is also the discipline in life, habits, outlook that enables a judge to be impartial. Its existence depends, however, not only on philosophical, ethical, and moral aspects, but also upon several mundane things. Security in tenure, freedom from ordinary monetary worries, freedom from influences, pressures within, from others in the judiciary, and without from the executive.
Then you can straight by come to paragraph 52. Because there are the judgments which have been
So, my
relied
lord,
on.
without, my lord, pressure from the executive. Now, my lord, kindly have, my lord, paragraph 53.
It is a 49 or the cardinal principle of the.
I'm sorry, my lord, kindly, my lord, have 49 also for a moment. In his concurring opinion, Pandian J stated, my lord, I'm reading 49. It is the cardinal principle of the Constitution that an independent judiciary is the most essential characteristic of a free society like ours.
52. 52.
Then, my lord, paragraph 52. Independence of the judiciary has always been recognized as a part of the basic structure of the Constitution. And, my lord, in this regard, my lord, reliance has been placed, my lord, on, my lord, various, my lord, decisions, which, my lord, are very well-known decisions, my lord.
But then if you come to paragraph.
So, my lord, your lordship kindly sees, my lord, that this entire judgment, my lord, the Supreme Court is seeking, my lord, to emphasize, my lord, that, my lord, you cannot, my lord, there is, my lord, a sponsoring ministry, my lord. Obviously, my lord, there is a sponsoring ministry. But, my lord, courts have to function, my lord, under the Ministry of Law and Justice. My lord, they can't be, my lord, therefore, my lord, the land tribunal will, my lord, be under the complete control and domain, my lord, of the, my lord, land department. The labor tribunal will be under the complete control, my lord. They'll work according to the dictate, behest, policy, guideline, everything, my lord, of the labor tribunal. So, my lord, if this is, my lord, the philosophy, my lord, behind, my lord, the affidavit, my lord, of the government, then, my lord, every, my lord, department will have its own tribunal, will have its own offices, and they'll have a tribunal, my lord, in one corner, and the tribunal will be a rubber stamp, my lord, or whatever the my lord, decision is taken, my lord, by the department. That is exactly, my lord, what is being attempted to be done. That, my lord, the court, and my lord, now, my lord, there is tribunalization in virtually every aspect. My lord, we have tribunals for motor accident claims case, we have tribunal for labor matters, we have tribunal, my lord, for every, my lord, virtually every matter under the sun. So, my lord, the attempt is, my lord, that the courts, my lord, will work according, my lord, to their dictates and directives of the sponsoring department. So, my lord, if every, my lord, department now, my lord, now comes, my lord, with this philosophy that we'll all consolidate. There are various labor divisions, my lord, so everything concerning labor will be in one labor bhavan. And in one, my lord, floor of the labor bhavan, we'll house the tribunal as well. My lord, this cannot, my lord, be permitted.
It's no separation of powers.
Now, my lord, kindly have, my lord, in the same report, my lord, paragraph 53. In Ram Jawai Kapoor, state of Punjab, my lord, this is with regard to separation of powers now. This court explained the doctrine of separation of powers thus. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts of the branches of the government have been sufficiently differentiated, and consequently it can well be said that our Constitution does not contemplate assumption by one organ or part of the state of function that essentially belongs to another. Then, my lord, in N. Chandra Kumar's case, in Chandra Motor's case, I'm sorry, paragraph 54, my lord, kindly take it from placetum F. Paragraph 54 from placetum F. India was a strong, so-and-so control of so-and-so. Indeed, it is common knowledge that in pre-independence India, there was a strong agitation that the judiciary should be separated from the executive, and that the agitation was based upon assumption that unless they were separated, the independence of the judiciary at lower levels would be a mockery. So, Article 50 of the Directive Principles of Policy state that the state shall take steps to separate the judiciary from the executive in public services of the state. Simply stated, it means that there shall be a separate judicial service free from the executive control. My lord, this principle, my lord, has been taken and completely relegated, my lord, to the sidewalk, my lord, in the affidavit filed, my lord, by the state. Now, my lord, kindly have, my lord, 68.
57.
57, 68.
57.
My lord, kindly now have paragraph 57. The doctrine of separation of powers has also been always considered to be a part of the basic structure of the Constitution. Keshavananda Bharati, my lord, is relied upon, my lord. This is basically, my lord, reiteration of what they are saying repeatedly, my lord, ad nauseum in the judgment. Now, my lord, kindly have paragraph 68. Ministry of Law and Justice, 68, my lord, at page 43.
Sponsoring department.
Most of the recommendations of the Legat Committee report were accepted and culminated in the tribunals, Courts and Enforcement Act 2007. The Act recognizes that the tribunals do not form a part of the administration, but are machinery of adjudication. As a result of the said Act, the appointments to the tribunals are on the recommendations of a judicial appointment commission, not the sponsoring department. The sponsoring department that generates the disputes that the tribunals will have to decide has no say in the appointments. Neither the infrastructure nor the staff provided to the tribunals by the sponsoring parent department. Kindly, my lord, make a note of this. And they say, corporate bhavan, infrastructure I will provide. Completely, my lord, comes under their influence. Kindly, my lord, see, the appointments, neither the infrastructure nor the staff provided. Here they are attempting to do both. The tribunals have become full-fledged part of the judicial system with no connection or link with the parent department, a common tribunal service has been established as an executing agency in the Ministry of Law and Justice, with no connection to the parent department. Thereafter, my lord, kindly have, my lord, paragraph 120. This is where this.
Paragraph 120 begins at till the conclusion. 120 it's
Madam.
page in the page, page 65. Page 65.
My lord, paragraph 120 is at page 65.
We may tabulate the corrections.
We may tabulate the corrections required. So, my lord, they are suggesting now the Supreme Court, my lord, and my lord, your lordship will see this is a full bench decision of the Supreme Court, comprising, my lord, of 5 learned judges. We may tabulate the corrections required to set the defects in Part 1B and 1C of the Act. They've completely ignored, my lord, the diktat of this judgment. Only judges and advocates can be considered for appointment of judicial members of the tribunal. Only High Court judges or judges who have served in the rank of district judges for 5 years and so on. So, my lord,
No, not that one.
this is, my lord, how?
Para 11 and 12.
No, 82 ta dekho. My lord, then, my lord, kindly have Roman 2. 120 Roman 2. As NCLT takes over the functions of High Court, my lord, this is very important. As NCLT takes over the functions of the High Court, the members should be, as nearly as possible, have the same position and status as High Court judges. This can be achieved, and he says, my lord, they're part of my ministry. I want better cohesion. They'll work under my diktat. I'll put them in the same room, same building. We are fortunate they didn't say, my lord, they'll share the same desk. This can be achieved not by giving salary and perks of a High Court judge to the members, but by ensuring that the persons who are nearly equal in rank, experience, or competence to High Court judges are appointed as members. Therefore, only officers who are holding the rank of secretaries of additional secretaries alone can be considered for appointment as technical members of the Company Law Tribunal. Clauses C and D, so and so, subsection, which provide for persons with 15 years experience in Group A post, holding the post of Joint Secretary or of the central government being qualified for appointment as members of the tribunal are invalid. Even Joint Secretary posts, my lord, invalid. Now, my lord, technical members are dealt with. So, my lord, technical members themselves have to be, my lord, very, my lord, qualified, my lord, and highly, my lord, respected, my lord, members, my lord, of the civil service. Then, my lord, kindly see. Judicial. My lord, kindly now have, my lord, Roman 11 XI, Roman 11 XI. To maintain independence and security in service, subsection 3 of 10FJ and 10FV should provide that suspension of the President, Chairman, Member Tribunal can only be done with the concurrence of the Chief Justice of India. Then, my lord, 12, the administrative support for all tribunals should be from the Ministry of Law and Justice. Neither the tribunals nor their members shall seek or be provided with facilities from the respective sponsoring parent ministry or department. My lord, on the basis of this line alone, my lord, I am, my lord, requesting your lordship, my lord, to completely, my lord, set aside, my lord, this, my lord, proposed transfer. No, neither the tribunal nor their members shall seek or be provided with facilities from the respective sponsor. My lord, this is, my lord, the shifting, my lord, to corporate bhavan, comprising, my lord, with, my lord, 5 other departments, my lord, is, my lord, in direct, my lord, contradistinction, my lord, to, my lord, this directive. This is not, my lord, an obiter of the Supreme Court. This is a directive of the Supreme Court, of a full bench decision of the Supreme Court. Neither the tribunals nor their members shall seek or be provided with facilities from the respective sponsoring or parent ministries, which is, my lord, the Ministry of Corporate Affairs, my lord, now seeks. And, my lord, this is, my lord, digressing for a moment, my lord, this is, my lord, what we, my lord, see, my lord, appearing in the NCLT every day. My lord, the learned members say that we are under an instruction to dispose of these matters. I have it on record. It comes in the list that these are specially marked matters. So the ministry decides the priority in which matters are going to be taken up. And that is the reality. All of us face this every day. The ministry decides these are matters which require special consideration to be taken up. No adjournment will be given. There is a separate category, priority list, which is starts from 101 to however many matters are designated. No adjournment in these matters. So virtually if this sentiment is allowed to percolate, then with the utmost of respect, it will not remain confined only to the Ministry of Corporate Affairs. It will spread to every other ministry. Now, kindly permit me to invite your Lordship's attention to the second decision, which is
Union of India Cheta Dakala Madras. This has been followed by Nageshwar Rao in 2020. আমি দিচ্ছি তো এটা জজ সাহেবকে দিচ্ছি তুমি আমাকে থেকে দাও আক্রমণটা তুমি নতুন তো সেম প্রিন্সিপাল দিস ইজ রিআইটেটেড once again and deals with NCLT.
Kindly now have 2019 volume 4 SCC page 17. This is the Swiss ribbons case. Kindly first have again the case starts from page 36. The report starts at page 36. So this is decided. Justice Nariman decided so many issues. Swiss ribbons. 2019 4 SCC page 17. Kindly permit me to start with paragraph 2 to show to your Lordship what was being considered. So, paragraph 1, the present petitions assail the constitutional validity of various provisions of the Insolvency and Bankruptcy Code. Then, paragraph 2, this is very important. Sri Mukul Rohatgi, learned senior advocate appearing for the writ petitioner, has first and foremost argued that the members of the National Company Law Tribunal and certain members of the National Company Law Appellate Tribunal, apart from President, have been appointed contrary to the court's judgment in Madras Bar Association versus Union of India. And therefore, this being so, all orders passed by such members being passed contrary to the judgment of this court in the aforesaid case ought to be set aside. In any case, even assuming that the de facto doctrine would apply to save such orders, it is clear that such members ought to be restrained from passing orders in future. In any case, until a properly constituted committee in accordance with the aforesaid judgment reappoints them so and so. Now, kindly take pracetam G, the same page. However, this is very important. Even today, NCLT and NCLT are functioning under the Ministry of Corporate Affairs. This again needs to be corrected immediately. A further technical violation also exists, that if the powers of the High Court are taken away, NCLT as an appellate forum should have the same convenience and expediency as existed prior to the appeals going to the NCLT. Since NCLT as an appellate court has a seat only at New Delhi, this would render the remedy inefficacious, inasmuch as a person would have to travel from Tamil Nadu, Calcutta, Bombay to New Delhi, whereas earlier they could have approached the respective high courts. My lord, kindly, pause here for a moment.
Efficacy আর এই যে লাইনটা বললে convenience.
My lord, kindly pause here for a moment and permit me to, my lord, show to your lordship that, my lord, the date of this judgment,
2019.
My lord, the date of this judgment, my lord, is, my lord, 25th January 2019. My lord, it will be my endeavor to show to your lordship that, my lord, directives of the Supreme Court to open, my lord, satellite benches of the NCLT in all the metro cities have not been implemented for a period of 6 years. So, my lord, any appeal previously, my lord, under 10F of the 1956 Act, my lord, we could come to the High Court. So, any appeal, my lord, from the, my lord, NCLT, my lord, one has to go to, my lord, Delhi. And, my lord, over here, my lord, your lordship will see, they formed a Chennai bench, but no other bench in Calcutta. My lord, I had flagged this concern as well, my lord, although I must concede this does not directly form a part of this writ petition. I had flagged this concern, my lord, when the matter was being heard by my Lady Justice Sarkar. And, my lord, it appeared to us that, my lord, there was a direction upon them to file a report, but it doesn't reflect in the order.
There is a direction for
Oh,
filing
I'm
the
sorry.
report. Last page, I saw the direction is
Yes,
there.
yes, I'm sorry, my lord. I'm sorry. The last line, my lord, kindly have that.
Yes.
The last paragraph of that order of Justice Sarkar. On the returnable date, central government will come back with a report as to whether, upon consideration, the construction of the new building, there would be proposal for setting up of the appellate tribunal. So, my lord, from 25th January 2019, it has been the mandate of the Supreme Court that, my lord, can kindly see, my lord, at the risk of repetition, my lord, kindly permit me to place this paragraph once again. However, even today, so, my lord, in paragraph 2, my lord, as Mr. Bose is saying, that, my lord, the two legs on which, my lord, this direction has been given are, my lord, convenience and efficacy.
So today you send me from the High Court area.
However, even today, NCLT and NCLT are functioning in Ministry of Corporate Affairs. Again, needs to be corrected immediately. So, my lord, this has not happened, my lord, in 6 years. And there is nothing, my lord, in the affidavit filed by them as to when they will, my lord, right this wrong. Now, my lord, kindly come straight away to paragraph 33. 33 থেকে শুরু করি কোন পেজ বলো My lord, your lordship finds paragraph 33 at page 57. The learned Attorney General, paragraph 33, has assured us that this judgment will be followed. Kindly, let's see. The learned Attorney General has assured us that this judgment will be followed and circuit benches will be established as soon as it is practicable. In this view of the matter, we record the submission and direct Union of India to set up circuit benches of NCLT within a period of 6 months from today. That means, my lord, their time ran out on 25th July 2019. And they are in violation of the Supreme Court order. And they do not say, so, my lord, when the NCLT comes, my lord, they will obviously treat that also to be a part of their department. But they don't say whether, my lord, that department can also house the NCLT. NCLT, they have to establish. This order of the Supreme Court is crystallized, no review, nothing. So, by no stretch of imagination can they say that we will not implement it.
Same principles
Is, my lord, the assurance, my lord, of the highest officer, my lord, of the Union of India, and in the form of an undertaking. Assurance, in the form of an assurance. And that assurance, my lord, is accepted, and then, my lord, a direction is issued. So, my lord, tomorrow, my lord, if they say that very well, we don't have any place in the corporate bhavan for the appellate tribunal, we'll have the appellate tribunal in Sundarban. It's part of public policy, you can't interfere with it. So, my lord, stakeholders, lot of people in Sundarbans also. So, my lord, there's no control. So, my lord, on the one limb, my lord, kindly see, my lord, the conduct. On the one hand, they don't follow Supreme Court orders. And this non-following of Supreme Court orders is in two limbs. They refuse to, my lord, acknowledge that the Supreme Court in no uncertain terms has said that you will have to separate the courts from the sponsoring ministries. And they, my lord, in directly, my lord, flouting the Supreme Court order, seeks, my lord, to include the court in the premises, my lord, that they are constructing for their ministry. And, my lord, Categorically, my lord, the Supreme Court says you cannot accept the infrastructure or any facility from your sponsoring ministry. So, my lord, the first violation, my lord, of the entire, my lord, law, my lord, laid down by the Supreme Court is with regard to, my lord, completely flouting, my lord, the separation of powers principle. And the second is, my lord, within 6 months, you're supposed to formulate nothing. Now, my lord, your lordship will not find one line, my lord, in the affidavit filed by them as to, my lord, where they plan to house the NCLT, my lord, which they must, my lord, establish. When they will establish, my lord, I'm not even going into that question. And my lord, when they do, my lord, where they, my lord, if they house the NCLT, my lord, now, my lord, in the existing building, then, my lord, again, my lord, there has to be, my lord, this. So, my lord, kindly see, my lord, the total, my lord, lack of, my lord, planning, and kindly, my lord, also appreciate, my lord, complete non-application of mind. And, my lord, the basic thing is, my lord, courts are, my lord, for the people.
And they're taking shelter of public policy, the policy decision. A policy decision is.
My lord, policy decision, according to, my lord, the affidavit, is only, my lord, policy decision looking after the convenience of the Babu. The Babu is finding it inconvenient to travel from Nizam Place, my lord, to, my lord, Esplanade. So, my lord, they formed, my lord, a nice, excellent, please, my lord, send all the departments there.
Paragraph 34, you have to show.
Then, my lord, kindly have.
Policy decision has to be based on public policy. Not have a policy decision.
Then, my lord, paragraph 34, tribunals are functioning under the wrong ministry. My lord, I don't know, my lord, if they even read, my lord, these reports. Shri Mukul Rohadi argued that the Madras Bar Association specifically records as follows. We may tabulate we showed this paragraph, my lord. We may tabulate the corrections required. Then, my lord, the same thing.
The administrative support for all.
Neither the tribunals nor their members shall seek or be provided with facilities from the respective sponsoring or parent ministry or department concerned.
Next slide.
Even though 8 years have passed since the date of this judgment, the administrative support for these tribunals continues to be from the Ministry of Corporate Affairs. This needs to be rectified at the earliest. My lord, I don't, my lord, think I need to place my case any further. My lord, one decision of 5 judges of the Supreme Court passed, my lord, in 2010. One decision, my lord, of, my lord, 2 judges of the of the Supreme Court, my lord, reiterating that you should do it within 6 months. Appellate tribunal. This needs to be rectified at the earliest. My lord, I do not know, my lord, if stronger terms could have been used. Even though 8 years have passed.
Now 12.
Now, my lord, 12 years have passed.
So 13.
My lord, it almost appears sometimes, my lord, that, my lord, the government, my lord, is law unto itself. And, my lord, kindly, my lord, check this propensity, my lord, to, my lord, completely take control of the judiciary. Because, my lord, although, my lord, NCLT judges, my lord, irrespective of what, my lord, has been said by the Supreme Court, my lord, they are not High Court judges, but, my lord, they are, my lord, dispensing justice, everything, my lord, Civil Procedure Code applies, everything applies. The entire company legislation, my lord, the thickest book in the library is the Companies Act.
35 and 36 you have.
Then, my lord, 35 and 36 quickly. 35 and 36. However, the learned Attorney General pointed out that Article 77(3) of the Constitution of India and the Delhi International Airport case, which states that once the rules of business are allocated amongst various ministries, such allocation is mandatory in nature. According to him, therefore, the rules of business have already allocated matters which arise under the Insolvency Code to the Ministry of Corporate Affairs are mandatory in nature. Then, Mother, kindly see 36.
This is very important.
It is obvious that the rules of business, being mandatory in nature and having to be followed, are to be so followed by the executive branch of the government. As far as we are concerned, we are bound by the Constitution, basic bench judgment in Madras Bar Association. This statement of law has been made 8 years ago. It is high time that the Union of India, both in letter and spirit, follow the judgment of this.
The entire affidavit in opposition is the Ministry of Corporate Affairs, their
আর কি
offices.
বলবে আর কি বলবে
22 তে
my lord,
another
another judgment my lord
is also on separation of power where
দেখা দেখা জজ সাহেব কি এটার মধ্যে দেখাবো
this is also subsequently been reported
They're
in
not to be shown,
2022
they're not
12.
to be shown to the
উত্তরাখণ্ড কেন দেখাবে না? আচ্ছা ঠিক আছে
Well, maybe I may hand over the iPad to you, Lordship.
Give the case number, I'll take down.
Yeah,
Citation.
My Lord, 2022 12 SCC, page 455. So I have sent for the book, my lord. In the meantime, my lord, if your lordship may just
No, you read out, it's okay.
very well my lord, we'll read it out my lord, this is my lord judgment rendered by Justice Nageshwar Rao my lord, paragraph 1 সবই উল্টো তো iPad paragraph 1 my lord, about 5-7 lines from the top my lord, the challenge is tribunal so and so are violative of the principles of separation of power and independence of judiciary, apart from being contrary to the principles laid down by the court in Union of India versus R. Gandhi, Bar Association, Madras Bar Association, which, my lord, is the first judgment, my lord, which we place for your lordship's consideration. Paragraph 2. A brief reference to the historical background of tribunalization in this country is necessary. So, my lord, they, my lord, go ahead, my lord. Tribunalization of the country. Now, my lord, paragraph 6 of this report, the Companies Act 2013. So, my lord, this is when, my lord, the Companies Law originated. Hereinafter referred to as the 2013 Act, which replaced the 1956 Act, contains provisions for establishment of NCLT and NCLAT. Madras Bar Association filed a writ petition under Article 32 of the Constitution, challenging the formation of NCLT under 408 of the 2013 Act. Several other provisions pertaining to constitution of NCLT and NCLAT, qualifications for appointment of members, chairperson, so and so, and selection committee were also assailed in the said writ petition. In Madras Bar Association, so and so, upheld the validity of Section 408, by which NCLT was constituted. However, clauses A, E of 409 relating to appointment of technical renders rendered invalid a direction given to the Union of India to scrupulously follow the judgment. So, my lord, ঠিক আছে আর একই জিনিস তো
separation of powers.
Then, my lord, in the same judgment, my lord, again, my lord, Justice Nageshwar Rao, my lord, paragraph 16, my lord, deals elaborately, my lord, under a separate heading, my lord, separation of powers. And paragraph 22, my lord, permit me to read paragraph 22. The doctrine of separation of powers informs the Indian constitutional structure and is essential constituent of the rule of law. In other words, the doctrine of separation of powers, though not expressly engrafted in the Constitution, its sweep, operation, and visibility are apparent from the scheme of the Indian Constitution. The Constitution has made a demarcation without drawing formal lines between the three organs, legislature, executive, and judiciary. Separation of powers between these three organs, legislature, executive, and judiciary, is also nothing but a consequence of principles of equality enshrined in Article 14 of the Constitution of India. Accordingly, breach of separation of judicial powers may amount to negation of equality under Article 14. Stated thus, a legislation can be invalidated on the basis of breach of separation of powers, since such breach is a negation of equality under Article 14 of the Constitution. Equality, rule of law, judicial review, separation of powers forms a part of the basic structure of the Constitution. Each of these concepts are intimately connected. There can be no rule of law. There is no equality if there is no equality before the law. These would be meaningless if the violation was not subject to judicial review. All these would be redundant if the legislative, executive, and judicial powers are vested in one organ. Therefore, the duty to decide. So, my lord, your lordship sees, my lord, here they say, my lord, it is
violation will be hit by Article 14. Then independence clause.
Then, my lord, another independent, my lord, chapter on, my lord, the independence of the judiciary. My lord, we'll hand up the judgments, my lord, with your permission, lordship's permission, my lord, we'll flag, my lord, the relevant. My lord, paragraph 27. The independence of the judiciary is a fighting faith of our constitution. It is a cardinal principle of constitution that an independent judiciary is the most essential characteristic of a free society like ours.
Cannot mix it with executive. That's exactly what they're trying.
Archi point. Archi what did I say?
Inconvenience of lawyers cannot be a ground to interfere with the position of the public does not appear to be inconvenient. This is incorrect because
Now, my lord, kindly, my lord, have, my lord, the two orders that have been passed in the matter. My lord, the two orders that have been passed in the matter, my lord, the first one is dated 17th May 2023. This is, my lord, absolutely at the ad interim stage. And I'm sure, my lord, Mr. Trivedi, my lord, will, my lord, point these out. So let me, my lord, try and preempt him.
My learned friends have become omniscient. My learned friends have become omniscient. They know what I'm going to argue.
No, I'm just trying to make an educated guess. My lord, kindly have this, my lord, order. The petitioner number 1 is the Advocates Bar Association of NCLT. Other two are claimed to be stakeholders. The petitioners are the petitioners are essentially a group of lawyers who practice in the NCLT and are concerned. My lord, I don't think, my lord, any longer it is restricted to a group, my lord. I find, my lord, whether it's original side, appellate side, my lord, I don't think it is restricted to, my lord, any body of lawyers any further, my lord. Initially, perhaps that was right. And are concerned about the proposed shift of location of the Kolkata bench and the present location to Rajarhat. Photographs annexed to the writ petition handed up by the learned DSG appearing for the Ministry of Corporate Affairs substantiate the apprehension. Learned counsels appearing for, my lord, seek to impress, my lord, your lordship can, my lord, bypass this, my lord, kindly, my lord, see the directions. My lord, kindly have it, my lord, from paragraph 5. I'm sorry, not paragraph 5, my lord. My lord, kindly have it from paragraph 6. In the present day, long distance stroke virtual communication, it is difficult to accept that lawyers will be forced to physically appear before a court of law. There is no evidence on record, at least at this stage, to show that lawyers practicing in the NCLT would not be permitted to appear virtually online. There is no evidence that the NCLT Kolkata bench has issued any notification to curtail this facility. The question is one of option, that is whether a lawyer chooses to appear physically or virtually before the court has been deprived of that choice. The petitioners continue to have that option, that there is no imminent threat to the availability of the choice. So, my lord, this order was concerned with an immediate ad interim order, that there is no immediate threat. The respondents shall deal with the writ petition, my lord, so and so, for affidavit in opposition. Needless to say, the proposed apprehension so and so shall not be intimidated, my lord. There was, my lord, a direction, my lord. The Honorable Chief Justice of India has stressed the necessity of continuing the virtual hearings. So, my lord, two things, my lord, your lordship will notice about the first order. My lord, the first order, my lord, does not consider, and my lord, rightly so, because it was not placed before a ladyship. My lord, the orders of the Madras High Court Bar Association, the orders, my lord, of my lord, Swiss Ribbons, and my lord, this order of Justice Nageshwar Rao. So, my lord, this entire argument with regard to, my lord, separation, my lord, and segregation, independence of judiciary was, my lord, at the ad interim stage, my lord. My lord, neither we troubled, my lord, the ladyship with this, nor, my lord, was this taken into consideration. Secondly, my lord, these are, my lord, prima facie findings, my lord, which, my lord, are relevant for, my lord, allowing or denying, my lord, an ad interim order. These, my lord, do not finally, my lord, I don't want to trouble your lordships, my lord. My lord, not even, my lord, these can't even form res judicata. And, my lord, the next portion, my lord, is that, my lord, virtual hearings have been directed, my lord, to be kept alive. Now, my lord, virtual hearings, my lord, till today have never, my lord, been used as a complete substitute for physical hearings. Until such time, my lord, the courts do not do that. I have an inherent right to, my lord, have myself physically represented before a court of law. I can understand, my lord, if everybody switches to the virtual mode, my lord, that which we did during COVID times, very well. But, my lord, when, my lord, some party, my lord, because he owns a car, has an option to appear physically, and the other party, my lord, because he does not own a car, my lord, has to appear virtually, my lord, then, my lord, my basic rights, my lord, are infringed with. My lord, other than that, my lord, this, my lord, particular order rendered, my lord, on this, my lord, 17th of May, does not consider, my lord, concerns only with the lawyers. Now, my lord, the court system and structure is, my lord, not only, my lord, lawyers. My lord, the litigants, the clerks, peons, bearers, advocates on record, my lord, the court clerk staff, clerical staff, even, my lord, the staff of, my lord, the learned judges and the members. So, my lord, this is, my lord, not considered in this particular, my lord, order. Next, my lord, kindly have the second, my lord, attempt by us, my lord, to obtain an interim order, which also, my lord, did not succeed. This is, my lord, the order of 3rd October. And, my lord, kindly have this order, my lord, from the my lord, from the second page. My lord, kindly have the last paragraph, my lord, at second page of this order. The Central Public Works Department undertook the construction of the new building at the project cost of 132.65 crores. Now, my lord, this appears to, my lord, have, my lord, weighed heavily with, my lord, the honorable court. Because, my lord, it is a large sum of money, my lord. Mr. Trivedi, my lord, in his usual very emphatic way, submitted this all go down the drain. It doesn't have to go down the drain at all. Please take every department of yours and put it there. Have a fancy office. We don't grudge you that. But don't put the court there and make it a part of your office. So, my lord, this, my lord, bogey which is being raised, my lord, I am only trying to address, my lord, this bogey, that 132 crores. You may have spent 532 crores. Who did you ask? Where is your notification? Did you even put out a notification? You did not. That this is all going to be shifted. Did you invite public opinion, my lord? I have, my lord, in my possession, my lord, a case of the Uttarakhand High Court, where, my lord, the, my lord, proposal was to shift the Uttarakhand High Court, my lord, from Nainital to Haldwani. On the ground that Nainital is a tourist spot, you put the High Court in the middle of a tourist spot, which is not the right thing to do. And, my lord, the High Court has held, the Supreme Court has held, not the High Court. The High Court has held, my lord, that you did not even undertake a consensus building exercise. You did not invite the stakeholders. You did not put out an advertisement. So, my lord, this is complete high-handedness. Excited হচ্ছিস না আমি দেব, of course we know, we have to give you judgments if we cite it. Now, my lord, kindly see 132.65 crores, my lord. What the government wants to spend on its officers, my lord, is the government's business, my lord. I have nothing to comment on that. Then, my lord, the authority is of the opinion that the other departments' offices of the Ministry of Corporate Affairs in Kolkata, CDS, SFI, should all be housed in one campus for convenience. Although there are 6 number of sanction posts, my lord, kindly now have to have this. So, my lord, this judgment, this order, my lord, of Justice Shorkar, my lord, with the utmost of respect, my lord, puts forward my case. You know, this is their avowed purpose, to have everything under one roof, and it is recorded. They have not challenged this finding. Then no, we don't want to really influence the court, judiciary. Members of the NCLT tribunal have been forced to work with only 2 benches due to space crunch. My lord, kindly, my lord, dwell here for a moment, my lord. Although there are 6 numbers of sanctioned posts, my lord, I'm reading the last portion, my lord, of page 2. Although there are 6 number of sanctioned posts for the members of the NCLT, tribunal has been forced to work with only 2 benches due to space crunch and a lack of infrastructure. My lord, I call upon my friend, and I will withdraw this writ petition if he proves me wrong. From 2016 till today, 8 years, we've never had a sanction strength. It is like saying that there are 72 judges of the Calcutta High Court. At least in 33 years, I have never seen 72 judges in one go. And, my lord, at present, my lord, we have, my lord, 1.5 courts. So the learned judicial member, my lord, presides over both court 1 and court 2. So she does half day court 1, half day court 2. So we have half a court each. And, my lord, in complete, my lord, amnesia of this aspect of the matter, they say 6 sanctioned posts, where we will put these judges. In 8 years, you've never had a full strength. Far from a full strength. You've always had between 2, 3 and maximum 4 judges. And, my lord, I'll tell your lordship, on 20th December, you will be left with 2 judges. And, my lord, there is no proposal, my lord, nothing in the anvil, my lord, as to when, my lord, these judges will come. They filed an affidavit. They should have said, these are the 6 people we've chosen for Calcutta. We can't appoint them because we don't have space. My lord, NCLT is all over India. And, my lord, if necessary, I'll put this in an affidavit. Cuttack NCLT, my lord, works for 1 day in a week. Half a day on Thursday, half a day on Friday. Cuttack NCLT. Why? They don't have members. Guwahati NCLT, Thursday and Friday, second half. First half, the judges take Cuttack NCLT. All virtual hearings because they don't have judges. So one gentleman is sitting, my lord, in Jaipur. The other gentleman is sitting in Nagpur. And, my lord, taking up, my lord, Guwahati bench. And here, my lord, the excuse is, where will we put the judges? There is not one NCLT, my lord, other than Mumbai and Delhi, my lord, who are, my lord, the favored children, perhaps. I don't know. Which, my lord, function on full strength. Let me just read this. Then, my lord, page 3 of the judgment. My lord, kindly see page 3, my lord, at the top. It was the policy decision of the central government to shift the premises of the NCLT regional bench to a new building. My lord, kindly pause here for a moment. My lord, this policy decision is where? In which, my lord, hidden government file? Why have you not produced it? I'm sure, my lord, 132 crores, my lord, must have been spent after obtaining the due sanction, my lord, of the relevant authority. But the justification, where is that? How do we know, my lord, that, my lord, the regional director himself didn't want a fancier office and therefore, my lord, decided to construct a building? Where is, my lord, the policy decision that, look, this is how the public at large will be benefited? They have, my lord, not disclosed that. So, my lord, this particular, my lord, paragraph, my lord, at the top of page 3, my lord, till today, my lord, that is not disclosed. If it's not disclosed, my lord, they can't hide behind it and say it's a policy decision. At this juncture, interference with such policy decision would not be prudent. My lord, absolutely, my lord, bow down. But, my lord, today we are at the final hearing. My lord. NCLT is situated at a heritage building and the laws prevent any kind of infrastructural changes. My lord, there are half a dozen other buildings, my lord, which are lying vacant within, my lord, 50 my lord, meters of the High Court. Half a dozen buildings, Council House Street. But, my lord, because this heritage building, and, my lord, as far as I am aware, my lord, my knowledge is very scant in this regard. Heritage building, my lord, only the facade cannot be interfered with. It is absolutely incorrect that, my lord, if the heritage building, my lord, including the High Court, my lord, we have, my lord, passages, my lord, outside courtroom number 9, your lordship will recollect, my lord, sometime, my lord, when Justice Bhattacharya was the Chief Justice, my lord, it collapsed, caved in. So, my lord, where do they get this from that, my lord? Heritage building cannot be, my lord. Only the outside, not the inside. Then, my lord, kindly see, my lord, the last paragraph, my lord, at page 3, in the decision of Swiss Ribbons, question before the Honorable Apex Court was whether the Ministry of Corporate Affairs could issue notification. So, my lord, we had, my lord, before Justice Shorkar, my lord, cited both Swiss Ribbons and, my lord, Madras High Court. And, my lord, ladyship has, my lord, duly, my lord, observed all this. My lord, the basic. Now, my lord, kindly come to, my lord, paragraph 5, page 5, I'm sorry. The ministry is primarily concerned with the administration of the Companies Act 2013, so and so, and the Insolvency Code and allied. Under such circumstances, it would not be proper for the court to stay the notification by which the proposal of NCLT Kolkata to the new building at Rajarhat has been made. It is true that the entire building is complete on the first, and on the first occasion itself, no interim protection was given. Order of her lordship clearly records that the petitioner so and so aggrieved by the profession would suffer. The inconvenience of lawyers cannot be a ground to interfere with policy decision, public policy. So, my lord, with the utmost of respect, my lord, and completely bowing down to this order, we didn't even prefer an appeal against this order. But, my lord, kindly see, my lord, that there is no, my lord, while, my lord, Swiss Ribbons and Madras High Court, my lord, is, my lord, taken note of. My lord, there is no further discussion on this. So, my lord, at the interim stage, it was not touched. And, my lord, it was held, my lord, only inconvenience of lawyers. My lord, it is just not the inconvenience of lawyers. My lord, as your lordship, most lawyers, my lord, have, my lord, big or small, my lord, forms of transport with which, my lord, they can. But, my lord, it is, my lord, the complete attempt, my lord, to subvert the independence of the judiciary by, my lord, treating it to be a limb of the Ministry of Corporate Affairs. My lord, these are my respectful submissions.
My lord, I should come back, if my lord so permits, on Monday, my lord.
Monday, Commissioner, Tuesday, Monday.
My lord, because, my lord, I tell you, my lord, not because I am prepared, my lord, but then I will take another half, my lord. There are
Half my day is
therefore,
gone.
my lord, what I humbly submit is, my lord, I'll take not more than half an hour. So, my lord, will kindly, I beseech, my lord, keep it on Monday or subject to whatever my lord writes, I will complete it, my lord. Because, my lord, there are 3 limbs of my argument. I'm putting it forward, just taking 30 seconds of my lord. First limb of argument is whether this point which has been pleaded before my lord at this stage, my lord, has ever been pleaded in the writ petition. And I speak when I've spoken to. So the allegation of the points which are not taken in the writ petition, I will not take all the points in my opposition under the sun from nail to an elephant. 1. Now, my lord, as far as independence of judiciary is concerned, that is a decision which is to be taken if shifting of NCLT from central Calcutta to corporate Bhavan will not help the purpose of independence of the judiciary. It will function in the same manner. So, my lord, these are 2 different questions which are to be decided. It has nothing to do with shifting. So, be that as it may, my lord, I will amplify myself on Monday if my lord kindly allows me.
There is a direction for filing a report. Is
My
your
lord, I have
report
got it.
ready?
I've got the report. Since, my lord, they started, my lord, my learned senior friend started, my lord, his argument, my lord.
Maybe have a copy, my lord,
Yes,
with your lordship.
I have got it. My lord, I have.
And just tell me one thing.
Lordship.
When you are moving NCLT from here to there, what are you all proposing to do with this space that you will get upon moving?
Well, we have categorically stated that in our affidavit in opposition in paragraph 5 and subparagraphs. Now, my lord, and that has been, my lord, also considered by the Honorable Coordinate Bench of this Honorable Court when the matter was being moved on 3rd of October. So, my lord, all these things had been considered.
What will you do with this space? The space will be vacant.
Here, my lord.
Here in Kolkata.
My lord, may I say, my lord, that I don't know. I don't want to make any submissions off the cuff. But, my lord, what happens is what I could understand from my affidavit in opposition. This is a makeshift arrangement because this building being a heritage building, since we did not have makeshift arrangements have been made in the past with regard to various tribunals, my lord. And as soon as, my lord, for example, and it is not today the first thing, my lord, corporate, the commercial court is in Rajarhat. NGT bench is there in Rajarhat. Armed Forces Tribunal, which is again, is in Hastings, my lord. So it is not something which is happening for today. And my lord, even the Honorable High Court building, that land was inaugurated in 2018. So, my lord, that is also on the pipeline, my lord. Be that as it may, I'm not arguing something which is far-fetched. But my lord, what I'm just trying to point out very humbly before my lord, that this is not something that has taken place just today.
No, I follow. I
So, my
just
lord, as far
wanted
as
to know.
what we will do, my lord, specifically, I will take instructions. I'll come back on Monday. My lord. So, my lord, I suppose my learned senior friend has some.
Can it be on Tuesday, my lord? Monday, I'm
Very good.
deeply obliged.
I'm indebted. Madam,
Learned Senior Counsel representing the petitioners commences and concludes argument. Stop. Report filed by the Deputy Director, Ministry of Corporate Affairs, dated 12th November 2024, be taken on record. Stop. To allow the learned advocate representing the respondents to make submission. List on 26th. And a stitchful.
My lord, if it is not too inconvenient to the court and, my lord, to my friend, my lord, can it be 27th? I find, my lord, that my colleagues, my lord, junior colleagues, my lord, some of them will not be here.
Very well, 27th.
27th. I'm so indebted.
I'm grateful, my lord. My lord.
Boita, take back the book.
हिंदी में बात करेंगे तो मैंने एकदम लिख लिया ना एकदम दिल में दिल मैंने बोला देखो सच में रखा सही है ऐसे हमको नहीं
Lord, I am appearing for the petitioner. Lord, I am.
Is it a similar matter?
Lord, in short, Lord, I am I am challenging an order now. Lord, that is challenging an order, Lord, that's passed by the district level committee of WB, CG, MA, and district magistrate and collector, based on the basis of a report, Lord, that is, Lord, passed by a committee, whereby, Lord, the demolitions have been directed to be passed. And this report, this order was based on a judgment order delivered by the tribunal consisting of 5 judges, 5 members. Just your lordship's kindly similar. The order is kindly
prior to you moving further, are all the respondents represented?
Lord, I appear for the West Bengal Pollution Control.
Well, I am for the
Everybody is.
I am for the Central Pollution.
well, I am for
AP to
the
Ashok.
well, I am for Union of India respondent number 1.
Who is for the West Bengal State Coastal Zone Management Authority? You represent. Then the
National Coastal Zone, possibly you cannot. Union of India, is somebody there?
Sorry, are we?
Union of India.
এই তো।
Yes. We are for Union of India.
You are there.
ফোন করিস না কেন?
Then everybody must be here.
Yes.
Yes.
My lord, kindly, first, similar, the order improved is at page 133. We are aggrieved now. Immediately. My lord, that's it. 11 November 2024. Kindly see, whereas as per order of Honorable NGT VD so and so regarding coastal regulation violation by hotels, restaurants, homestays in Mandarmani, Purvo Medipur, all stakeholders are hereby directed to demolish and clean your illegal construction within so and so. So who are the stakeholders? What violations have been made by them? Nothing is there. A simple non-speaking order. This has been passed. Anyway, my lord. Now, my lord, this is on the basis, kindly see, on the basis of an order that is, my lord, starts from page 18. No, page 18. 118. Not bullish, na. 120. Now, let kindly see, this is a order for demolition by a joint committee constituted by the Honorable Green Tribunal Special in terms of order date 2 passed in connection with the original application regarding gross violation of mandate of law and non-compliance of the Supreme Court causing damage to coastal and marine ecology and environment, Mandarmani, Shiaban, Purvo Medipur, so and so. Now, my lord, your lordships will find from the, if your lordships come to page 131, I am coming to the big judgment. Then I am come to the order, or not order, judgment, sorry. Now, similar, the rest 120 hotels out of 143 hotels as per Annex 2 and Annex 3, except 23 hotels mentioned in table 2 lie on the seaward side within CRJ 2 or in the periphery of CRJ 1 and CRJ 1B. Therefore, the operational of this hotel, etc., is not in compliance with the CRJ notification amended. Appropriate actions as deemed fit and proper can be taken so as to make the CRJ free from encroachment as observed from these hotels, etc. Established and operated controlling of the CRJ notification amended. However, it may be mentioned 49 hotels out of 120 had been granted consent to operate as per the Honorable answer. Now, what are the hotels? Which hotels have been got the consent? What are the norms? Nothing has been done. The most important point is, my lord, whether this committee is having any power of adjudication. If adjudication power is not there, how he can pass an order? Adjudication power is vested with the Green Tribunal. Green Tribunal has delegated the power to the Millard Joint Committee. Can it be done, Millard?
Technical thing.
A team. Can it, Millard, who will decide the dispute? Dispute will be decided by the statutory tribunal. Tribunal did not adjudicate. Tribunal didn't say which are the hotels have contravened the provisions, etc., etc. That has been delegated to a committee. Committee will earmark it. Committee will decide. Can the committee do it? And Millard, another, if kindly see just, lordships kindly come to, it starts from page, Millard, tribunal's order. That is the most important, Millard, and it starts from page 72, kindly come to page 72. See, my lord, this is the National Green Tribunal, Eastern Zone, Kolkata. See the, Millard, no, page 72, order improved. Kindly come to page 78. Page 78. See, my lord, the Constitution. Page 78. Page 78. See, 5 members were there. My lord, this is not permissible under the Act itself. देखिए
4C.
First similar 4C. 4C. The central government may, but in consultation with the chairperson of the tribunal, makes rules as generally by practice. Then see, the minimum numbers of members who shall hear the application and appeal in respect of any class or classes of applications and appeals. Then, Miller, provided the number of expert members shall in hearing an application or appeal be equal to the member of judicial members hearing such applications or appeal. Therefore, if there is an odd numbers, cannot.
Here it is 5, so it is odd.
It should be 6, 8, 4, whatever it may be. And Miller, I am fortified by on this point, a judgment of the Bombay High Court, Miller. Now, Miller, since I have come to the Act itself, let me show your lordship, Miller. Miller, kindly come to section 14 now. Come to section 14. First of all, section 14.1, the tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to, is involved, and such question arises out of implementation enactment of the specified in Schedule 1. 2. Tribunal shall hear the disputes arising from the question referred to in subsection 1 and settle, my lord, here my important point is, and settle such disputes and pass orders thereon. Third, no application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months from the date on which the cause of action for such dispute first arose. Then cause of action arose when the hotel was constructed, resort was constructed. And it started from 1996. How such a dispute can be entertained in the year 2019 or 2020, 18? Starting from commencement of 1996 to pre-2011, resorts have been made. আসছি দাঁড়া না একটু একটু থাম আমি বড্ড মোটা মোটা লোক আস্তে আস্তে যাই আমি
Yes.
Therefore, entertainability, tribunal had no power to entertain it. Next, Millard, very importantly, your lordships will find, Millard, just give me 1 minute time. A substantial এটা কোথায় দেখানো? Kindly come to section 20. Section 20. The tribunal shall, while passing any order or decision or award, apply the principle of sustainable development, the precautionary principle, and the pollutory pays principle. It is not the duty, go and demolish. Apply bulldozer policy. No. Tribunal has to see first that sustainable development, how it can be made, whether the precautionary principles can be done or not, and the polluter space principle. These are the basic of it. I must show to your lordship when I am section 22. Appeal to Supreme Court. Any person aggrieved by any award, nominal kindly see, award, decision, or order of the tribunal may file an appeal to the Supreme Court within 90 days. Correct, Mullah? Now the joint committee which has passed the order, that's not an appealable. That's not an appealable, whereby it has been directed to demolish. And they don't have the jurisdiction to pass the order. Now, Millard, kindly see what is the order was passed by the tribunal. Finally, kindly come to page 115. Kindly come to 150. Paragraph 20, my lord. In view of gross violation of mandate of law and on non-compliance of the orders of the Honorable Supreme Court, as observed above, causing damage to the fragile coastal resources, internal and coastal fauna, groundwater qualities, apart from closing illegal activities for further, liability needs to be fixed for damage already caused. Such damages has patently affected the coastal environment and coastal communities who depend on this precious transfer for the livelihood. Having regard to the period and extent of violations, all the private respondents except those who are found to be compliant with the CRZ notification. Kindly mark it, Miller. Compliant with the CRZ notification, the Water Act and other norms are held liable to pay environmental compensation to be fixed by a joint committee proposed in the later part of this order on polluter pay principle based on responso, considering the period of violation, nature of violation, and financial capacity of the unit. The committee may consider law laid down so. The same may be used for restoration of the coastal land. The amount deposited in the regional office Kolkata shall be kept in separate account to be used for restoration of the environment as per integrated coastal management plan from Diga Shankarpur so. Now, 21. In spite of clear violation noticed above, out of abundant caution, we provide further opportunity to the respondents, hotel, restaurants, or report claiming that existence operation to be valid under CRZ notification, otherwise compliance, it should be compliance to put forward their claim with all relevant documents before a joint committee of NCLT, PCB, State PCB, nodal agency within 2 weeks. If such claim is accepted, a rescission order may be passed within next 2 weeks. Can you delegate this part? And subject to such claim and order based on verification, there are all hotel restaurants operating in coastal in district NGG clearance outside such zone in terms of approvals as per are liable to be demolished to give effect to the law and order. Therefore, nothing has been adjudicated. Certain principles have been laid down. Adjudication were required to be done under the Act itself by the tribunal. And the principles which are there, polluters principles, polluters pay principles, substantial growth principle, etc., that has not been taken care by the another committee. That is the most fundamental principle. To demolish is not the object of the Act. If these are available, then you do it. That's the last resort. That's the last resort can be taken. Now, the committee has decided this joint committee. Joint committee judge order is not even a reasoned order. Joint committee has not identified. Joint committee has not entertained any claim. Joint committee has not, what is the reason, whom they are, what are the evidences have been considered? Ask. Now, my lord, most importantly, CRJ notification has not been made so far West Bengal is concerned. The question of breach doesn't come at all. Yeah, my lord, now my lord, there are number of, I do not want to take much of your lordships. Let me frame the questions to your lordships, my lord, before your lordships for considerations to your lordships. If a committee doesn't have the power for adjudication, can he pass to demolish? Power which was vested with the tribunal under the Act has not exercised the power. And the section 20, the parameters which have been there simply have been quoted. Parameters have not been considered. Therefore, whether it's a nullity or not, and the moreover, the point is 5 persons, that's the nullity itself. Committee's formation of the bench itself is a nullity. Now, just 1 minute. Lordship knows the blood. I am aware about this blood. Now, Lordship knows this blood that even order is without jurisdiction, writ court can entertain the matter. Law is so is well settled. I also take this point in collateral proceeding also. Writ court function and duties of the writ court ultimately is to see the substantial things. If an adjudicating authority does not discharge his duty delegated, my lord, that's a very simple thing. It's a totally illegal. Dispute was required to be heard. Now, my lord, I will show to your lordship just 2 judgment. আমারটা কোথায় গেল? জজ সাহেবকে দাও। কোনটা দিলি এটা? গোয়া ফাউন্ডেশন। My lord, this is the High Court of Bombay High Court. What is বললাম? That is the my lord, the Goa Foundation versus the National Green Tribunal. 34 to yes. My lord, kindly come to paragraph 34 first. Paragraph 34 first. We pause here to consider some of the statutory provisions in regard to the composition of any bench of the NGT. Section 4, subsection 4 of the NGT as says. Because this is this tribunal composition has been set out. Then, my lord, the proviso emphasis above prima facie indicates that judicial members cannot outnumber expert members. Which has happened here. 36, we also know notice rule 3, etc., etc., etc. Kindly come to then paragraph 40. Now, Alvarez draws our attention to a division bench order that is certain transfer of them by the Madras High Court. That court took the view one that we affirm that the Act and the rules do not permit a bench of an odd number of members. Submission is that if the number of expert members on any bench must be equal to the numbers of judicial members, then by necessary arithmetic, the bench strength must be an equal number. That is the proviso to section 4(4)(c). This is also why the first proviso to section 21 speaks of an opinion being equally divided, a situation that can only arise if there are even number of members. The provision for a single member sitting in the procedural rules only operates in exceptional circumstances. So and so submits that this entire framework has been thrown to the winds by the improved notices. Even assuming that the bench strength could be more than 2, it is unclear how under the Act and rules it can be ever the odd number. But if two members sit and are available in the Western Zone, then the state does not contemplate the case to answer. But this is on view of the case, principles have already been said. Ultimately, my lord, this kindly come to page 46. Paragraph 46, your lordships kindly see. 46. The section 53 puts that it is the chairperson who decides the distribution of business of the tribunals.
Sorry. But it is my fault. It should be 56.
যাচ্ছি ঠিক আছে তুই একদম তোরা তিনজনে মিলে চেঁচানোর মতো আমাকে বরঞ্চ কনফিডেন্স লেস করে দিলি তোরা তিনজনে মিলে rule is made absolute in terms of prayer. Clause A, all 5 input notices so and so are quashed and set aside. The constitution of the special city in New Delhi is illegal. Only the members of the Western Sunsumala, that is, because bench was required. Here, one of the question was where the bench will sit. Bench will sit at Goa. That was the bench. The bench took up the matter at Delhi. That is the one. But this is one of the aspects regarding the constitution of bench. Second judgment, Millard, I want to show. Millard, against this judgment, special petition was been referred by the parties, and there an order I have been told that an order of status quo has been passed. Anyway, Millard, next judgment, Millard, this is Millard, 2022 SCC online, Supreme Court 69. Madhya Pradesh High Court Advocates Bar Association and another versus Union of India and another others. My lord will come from it is really starts from issue read discussion, that's paragraph 18. Whether the NGT ousts the High Court jurisdiction under section 14 and 22 of the NGT Act. In so far as the, may I please, Millard?
Yes.
In so far as the contention of the petitioner that there is an ouster of jurisdiction of the High Court under Article 220 or 227 of the Constitution because of section 14 and 20, it must be recalled that L. Chandrakumar versus Union of India, it has been categorically declared that the power of judicial review under Article 220 are part of the basic structure of our Constitution, and the same is inviolable. The following pertinent opinion rendered in says transfer. Apart from the clear enunciation, paragraph 20, legal position to the effect that the NGT is within the purview of Article 227 of jurisdiction of the High Court, the learned Attorney General on behalf of India has also made submission consistent, my lord, kindly say, consistent with L. Chandrakumar. Then, my lord, details have been, all that case laws have been given, my lord, that regarding NGT, all I do not wish to, my lord, take your lordship's trouble. My lord, one of the very interesting line which I read it, just I am telling you, I have read it, and here the Supreme Court has, this says, you see, from area to you have to go to Delhi. That's not a acceptable position in every dispute. That is, it is there. Ultimately, your lordships will come to paragraph 45A. 45. Conclusion. In consequence of the above analysis, our considerations are the National Green Tribunal under section 14 and 22 of the NGT Act does not oust the High Court's jurisdiction under Article 226 and 227, as the same is a part of the basic structure of the Constitution. Then others are not. Therefore, this is it doesn't oust the jurisdiction. Above, leave aside this. Lordship is about the Whirlpool judgment is there. That is 1998 1 SCC judgment. 1998 1 SCC. Whirlpool judgment, Lordship knows that the তাড়াতাড়ি দাও না ভাই চলেও যায় সেই সময়তেই চলে যায় বার কোন sorry Millard, that I am wrong. 1998 8 SCC Millard principles, Whirlpool judgment. If there is a violation of constitutional right, Article 14, 19, 21, writ is maintainable. If there is a without jurisdiction, that's the writ is maintainable. These are the basic principles are there. Opportunity of hearing has not been given, then the writ is maintainable. That's a well settled principles of law. Therefore, here, number one, without jurisdiction. Number two, appeal tribunal did not adjudicate the main question and did not pass any order. Delegate its power to a committee. That committee doesn't have the power under the statute to decide. And after tribunal, nothing. And that committee's report order, there is no scope for preferring any appeal. If the committee's report takes away my right, that's illegal. District magistrate has passed an order without applying his mind at all. Nothing has been identified anywhere, Nothing has been identified anywhere. Next point, that is also on record. Consent applications have been filed. They did not take any decision. 60, 65 applications are long pending, long years. 6 months cause of action. Where is that pleading in the petition application, original application? Yeah, no. This during the last 6 months, this construction has been made. All these constructions have been made long back, right from 1996 to up to 2009, 10, 11, 12. Applications have been filed in 2018 or 19.
Application for what?
Before the tribunal. Before this is on before the on the basis of an application filed by someone. The entertainability point. Now, Lordship knows that principles, when here, the almost 140, 2040, they have invested huge money. A good numbers of workers are going on. Practically, it has become an industry there, a tourism industry. Livelihood of all the persons can be taken away. With an alternative, I am submitting that if your Lordship ultimately comes to a finding that's taking into consideration of the principles of the Act itself, that these are the things can be fulfilled. That's section I was reading. That section. Just give me 1 minute time, my lord. Section 20, kindly take section 20 once. The tribunal shall, while passing any order or apply the principle of sustainable development, the precautionary principle, and the polluter pay principle. If any principles have been laid down by the court, any directions is given by the court, and if I comply with such directions, these orders cannot sustain. This exercise has not been made by anyone, and this is a mandatory duty of the tribunal. Recent judgments I have forgotten. I have not brought it since I was arguing, So, but the property right is concerned, very recently Supreme Court has delivered a judgment, That's a very important in respect of Uttar Pradesh. Bulldozer policy was applied. Supreme Court has said, no, it cannot be done. If you want to demolish any building, you have to comply with all the provisions of the law. Eighth point. I will be making a prayer. I will very humbly submit. Kindly stay the operations of this demolitions. Otherwise, we will be facing a great difficulties, my lord.
This demolition was to be carried out within the 20th. Today we are on the 22nd. Did was any steps taken by the authority? So no steps have been taken.
As I have, I just tell you, Lord, I have read it from the, I don't know state what will be the state. I have read it from the newspaper that the policy has been taken by the state not to immediately to implement this order.
So you are protected to some extent?
No, that's similar, not legal. I read it in the newspaper. I don't know. I know notification has been made. No order has been made. And some decision has been taken. Because I have also this polluter policy may be looked into in the matter. That's the principle which I have shown to your lordships in section 20. Therefore, Milord, kindly stay this. Otherwise, I will be in great difficulties.
Yes. Who is going to argue first?
Item number 3 is separate.
Little bit separate.
Separate, slightly separate.
Would you like to argue so that the respondents can reply jointly?
Same always. Respondents complete in item. I'll make sure nothing.
He's going to improve his submission after hearing your submission. That is the reason. Yes.
Matter is concerned.
Hmm.
I have the DM has passed that improved order, which is annexed at the last page of the page 130, that is on 11th of November. But we have started in compliance of the report of the joint committee. And the joint committee has been constituted in compliance of the order of the letter. But I have nothing to say with regard to the constitution of that action because I have no business with regard to the I have just acted in compliance of the order, that much I can see. Joint committee's report is there, and I have issued that condition order, and I have said that they can come up to me. You can lordship that is the order. We have a directed to promote the action to be taken. Lord, we have given that directed 20th, but since the repetition was from the 14th, I believe it was served upon us. We have not taken the steps. So your matter is pending.
And how long will you all sit tight till the writ petition is decided?
You must take up the matter now.
Yes.
You must take up the matter with whatever order comes from your lordship, will take steps according to that.
No, since the matter is being heard, will you all take steps in the meantime?
Since the matter is pending, my lord, the principle of least pendants will apply, my lord, subject to correction by my lord.
Yes.
Till such time, my lord, if your lordship decides the matter, we will act accordingly.
You have to give the time to decide the matter. Right.
But I believe, my lord, there is a third writ petition which has been filed by Mr. Bhattacharya, my lord.
Third, second one.
That is the item number 3.
Yes, item.
There is a notice of hearing. Additional notice.
I place the
Hearing.
So there is a notice.
3 he is yet to argue, but then you intimated the court.
They have issued a notice for hearing, and the date of hearing is fixed.
No, those hearings will not have been postponed. We have been
Then postponed. It is postponed, then postponed. Has further date been given?
No.
Postponed, sine die.
Postponed.
Sine die.
Sine die জিজ্ঞেস করছি।
Sine die কি জিজ্ঞেস?
No, it will be communicated later.
May I answer?
Yes, yes.
An email has been received indicating that owing to unforeseen circumstances, the hearing stands postponed, nothing else.
So till, at least we can take it that till the hearing is given to you all, no steps will be taken by them.
Now, my lord, if they have completed, my lord, may I just add 2-3 things. First is, my lord, insofar as my matter is concerned, I adopt what my senior has submitted. Apart from that, my lord, I only am tempted to add, my lord, I am being led by Mr. Mukherjee. I am indicating to your lordship, my lord, he is slightly indisposed, my lord. He has requested, my lord, if a date, my lord, apropos what the state says. But prima facie, my lord, the foundation here is, my lord, on the entire thing, the foundation is wrong, illegal. The illegal assumption of jurisdiction by the NGT is also in question in my writ petition. I have specifically challenged Vishnupada Pakira's order because Vishnupada Pakira, my lord, my senior placed that paragraph where a committee has been constituted. The committee could not be constituted by a bench which has illegally assumed jurisdiction.
Why don't you prefer appeal?
No, there is no question of an appeal, my lord. I have come by way of a writ petition. Now, please see, my lord, please see Goa Foundation's judgment once. I mean, your lordship has seen Goa Foundation. My lord, apart from anything else, my lord, in Goa Foundation, please kindly takes the trouble to paragraph 46.
paragraph 46. Milord, it begins with Mr. Joshi lays some emphasis on Rule 3 and Section 4 to suggest that it is the chairperson who decides the distribution of business of the tribunal amongst members of the tribunal sitting at different places. The argument is misconceived. If there are multiple benches in one zone, then it is for the chairperson to distribute work between such local benches, just as the Chief Justice or presiding judge of any court distributes work between the multiple benches of the court over which he presides. The rule does not mean that the chairperson can randomly cherry pick matters from any bench and withdraw them to himself or to a bench over which he presides. Pausing here. This matter, Vishnu Pada Pakhira's matter, was always heard by a two-judge NGT bench in Kolkata, in Eastern Zonal Bench. Suddenly, Milord, we have appended the notices in my writ petition. Suddenly, Milord, notices started coming that a 5-judge bench will, Milord, suddenly, Milord, the 5-judge bench took over this matter. Why? When? For what reason? No one knows. And this 5-judge bench assumes jurisdiction. First of all, 5-judge bench has been pointed out by my learned senior, Milord. Absolutely correct. 5-judge bench not conceived in the Act. Not conceived. Even number is on the only, Milord, conception permitted by the NGT Act. 2, 4, 6, 8, whatever. But it cannot have 3 because it cannot outnumber. Milord, the sentence in paragraph 35 is it cannot outnumber, Milord, the expert members, or the judicial members cannot outnumber each one of them. That is one aspect of the matter. Now, this 5-judge bench, upon cherry picking, Milord, this particular matter, suddenly decided to take over it, decide the matter once for all, rightly, wrongly, and then sets up a committee. That committee is constituted by a bench which per se does not have jurisdiction. So the foundation again is wrong. And this committee, whichever has been constituted, that committee has apparently taken some, we do not know what has happened. Some notices have been received. We have responded to it by suggesting that give us papers. We have also taken the points regarding, Milord, jurisdiction, everything. No minutes, nothing has been furnished to us insofar as my clients are concerned. Nothing. Nothing has been furnished to us. There is no mapping. Your Lordship may note it, Milord, our specific cases. There is no mapping. I am not troubling your Lordship with that. But prima facie, no exercise has been contemplated or acted by any of the committees. The Coastal Zonal Management Authority in West Bengal, not acted. There is no mapping. Which hotel is in violation of what, as my senior has pointed out? No one knows. Now, Milord, in the given facts, now, Milord, what happens is my duty, Milord, as a counsel to appear. Milord, in my matter, there is a subsequent development, Milord, which also, Milord, everyone knows.
Names of certain hotels are
Yeah,
mentioned in
that is in that matter, in Vishnu Pada.
Yes, yes.
Now, Milord, kindly visualize. Some of the hotels were represented by us. There is no doubt about it. Now, Milord, these hotels, whether they are in violation or not, a committee has been constituted by an illegal bench.
No, that I
Milord,
follow.
that apart, Milord, what I am respectfully submitting, now a suo motu matter comes up before the tribunal in 2024. The petitioner does not remain represented before the tribunal. The tribunal assumes jurisdiction of that matter, and, Milord, in the light of Vishnu Pada Pakhira, that is 2022 order, May 2022 order, directs the state report compliance. And whatever action today is being taken and the basis is wrong, the foundation is wrong, the foundation is without jurisdiction, and entire thing, according to me, in my humble submission, as we have, Milord, Mr. Mukherjee has also requested us, it's quorum non juris, Milord, it's a nullity. So therefore, your Lordship will kindly, Milord, not, the state has to not only stay, it cannot proceed even an inch. And my, apart from any other prayer, I have also an additional prayer. In the month of December, we are, Milord, the state has to report compliance before the NGT in the other matter. Your Lordship will kindly stay the proceedings, the main proceedings altogether. The proceedings cannot proceed, Milord, because the proceedings is proceeding on the basis of an order made by a 5-judge bench, which is illegal.
I have so many points. Just I have given 2 or 3 points for the time limit. geo, etc., etc. I have not gone into
Well,
that merits also. Only the
yes,
point of law I have.
Hearing for behalf of the Central Pollution Control Board, Lordship.
yes.
Lordship, I'll trouble my Lordship to kindly take page 86 of the petition, wherein an affidavit, it's clearly stated in the order that the affidavit of His
Pollution
Lordship will
Control
be-
Board.
Yes, West Bengal. Here, all the details of all the hotels who are operating without the consent. I'm not getting into the fact where my learned senior friend has stated the legal point. I'm not pressing on that. That my lord will decide and adjudicate. But here, the details have been given of all the hotels who are operating without the consent. The details has been given, page 86,
Serial number 10.
serial number 10.
Serial 10.
Lordship will
Four.
again take page 88. Then then it seems that this order has no nothing. It's only the environmental issue will take a back seat. The authorities who are protecting, who are giving the responsibility to protect the environment will be a toothless tiger. Lordship has page 88, Annexure 1. So in all the meetings which were directed by the NGT, even the Hoteliers Association and the stakeholders, they have all participated in that. Now at this point of time, they cannot come up with the fact or with the point that the entire thing is illegal. Of course, that my lord will decide. Page 89 also has the continuation of all the annexures.
Other petition.
So annexure, the notification of 11th of November, that is P8. That is the ancillary portion of all the NGT orders and all the meetings which have been held.
Tell me one thing, why did not you all make this Pakhira as
And I have
respondent?
made him a party in my matter. I have served him notices. And the subsequent Satyendranath Chatterjee or something, Milord, Shoilendranath Chatterjee. In this 2024 matter, Milord, OA, which I have prayed for a specific stay, that gentleman has also been indicted as a party and we have served notices on both. My affidavit of service.
In item number 2, the Pakhira is not there. This is the reason I was wondering.
Like item number 3, we have made him a party. Kindly take my affidavit of service on record.
And tell me one thing,
My lord.
the impugned order that has been placed, it mentions about illegal construction, where the constructions made pursuant to any sanction granted by
Yes,
any
yes, yes.
authority.
All permissions taken from every possible authority, starting from the sanctioning authority to, Milord, the pollution authority. We have set up plans, Milord, effluent treatment plants, ETPs, everything is there.
No, for the purpose of construction, not for the
Yeah,
purpose of
yes, 100%. All permissions are there.
municipality
Look,
and everything.
Exactly, that's the reason I was saying, Milord, just one.
Sorry, sir.
That where you have identified, it is a omnibus cannot be said. They have omnibussly the order. Milord, I will go by the order impugned. Nothing has been, Milord, said. Then I can give an answer. Milord, the problem I just, Milord, which if you read the entire things and ultimately, which will come, whether the consent has been granted by the appropriate board or not. Correct, Milord? Consent now, if a lordship just can't come to just.
Page 88, your friend has shown, there is a chart where it mentions about an inspection being conducted in 2021, not once, but in several occasions. page 96, that is annexure 2. It mentions about an inspection, and these are the hotels which have been identified, not yet obtained CFO, not produced the CFO.
Exactly,
you
I was
knew
telling
it.
that. I was telling. They are saying I have not obtained. We are saying 60 applications are pending. They are not disposing. That is the whole problem. Question is, if I am the question is, my lord, whether I am entitled to get it. You may reject it. I don't mind. I can challenge. But do something. You are not issuing the licenses. That is consent certificate. And you are saying, no, I have not obtained. How can there be two standards, my lord? How can there be two standards? They are saying, kindly come to this order, page 131. See, at a glance, whatever, my lord, at a glance, if we see this whole thing, at a glance, to prejudice anybody, these facts are very bad for us, no doubt. Read, Lord, paragraph 2. The rest 120 hotels out of total 143 as so and so lie on the seaward side within CRZ 2 or in the periphery of CRZ 1A and CRZ 1B. Therefore, the operation of this hotel, etc., is not on compliance with the CRZ notification as amended. Kindly mark it the CRZ. Where is that notification so far West Bengal is concerned? When this notification has been made? If the notification has been made, my lord, in 2018, my construction was in 2008, can it be given a retrospective effect? One of the important questions. Nobody is deciding, just everybody is just looking into the top of the fact, finished. Where is that notification? When I have constructed?
Is there a notification?
Now, kindly read this, just I will see. Appropriate action as deemed fit and proper and taken so far CRZ free from encroachment as observed from the hotel established operated. However, kindly see now, it may be mentioned 49 hotel out of the 100 had been granted consent to operate. There were 120 you are saying, later on you are coming. No, these 43 have been granted. 49. And what I have submitted to your lords, I have submitted 50 to 60 applications for the consent to operate. Is pending for adjudication for years after years. Am I responsible?
Lordship, only one thing.
Is there the CRZ regulation?
Yes, there is a regulation. It is categorized into 3 zones. Zone subject to correction. I don't, because I don't have the hard copy of the brief subject to correction. That these are the very sensitive zones where it's a where the high tide zone is there.
Where is
But
the notification?
I don't have it with me, Lordship.
Does it exist in respect of West Bengal?
Yes.
It does.
Check on that.
My lord, that's the
As
whole,
of now, I'm not commenting.
that's the whole problem. CRJ notification after that identification. What is the CRJ1? What is the CRJ2? What is the CRJ3? That work has not been undertaken in the West Bengal.
Very well.
One thing that consent.
Let a comprehensive affidavit comes.
Yes.
Consent to operate comes later part. Whether the hotel can be built or not, that is the primary question to be decided.
I was inquiring as to whether the construction itself is in accordance with law, whether any permission has been. What is the Union of India stand?
Union of India only before taking that point, your article is at page 21, what they have stated. If it is found, Miller, that is illegal order, constitution of the committee, they are challenging the ultra-virus. They have stated ultra-virus. The pair is also there, and they have not made party.
Who has not been made party?
Members, the
Solicitor General.
Ultra-virus of
Section has
what?
not been talked about.
Or here in Miller,
Ultra-virus of what?
No, Miller, I'm only submitting the ultra-virus. Rules are ultra-virus.
Where is that mentioned?
Here, logically, is page 21, middle portion.
Middle portion. Where?
The order dated such and such does not provide for the mandate automatic demolition against Chairman such and such without specific mandate. The order without jurisdiction ultra-virus.
Order is ultra-virus.
Ultra-virus.
Order.
No, the law has not been challenged.
Your lordship, pair, Miller, your can see the pair. Pair. Pair E.
না সবকিছু কি ওদের আমার কি জানে
Submission is that the CRZ notification is not there. So the
Yes, it is
question
not.
of its ultra-virus.
The specific pleading is there in both the petitions.
So the question of declaring it ultra-virus doesn't arise if it doesn't exist at all.
The instruction is necessary to produce the record, my lord. The general question.
Very well, please come. Item number 2 and 3 will be separate orders. Give me the file of item number 3. Item number 2. Item number 2, please take down. The notice dated 11th November 2024, issued by the chairman, district level committee of WBCZMA
Only
and district magistrate and collector Purva Mednipur, directing all stakeholders to demolish and clean the illegal construction within 20th of November 2024 by the hotels / resorts and homestays in Mondarmoni, Purva Mednipur in terms of the order of the National Green Tribunal in OA number 134/2015/EZ dated 2nd May 2022 is impugned herein. Stop. Primary contention of the petitioner is that the CRZ notification in respect of the state of West Bengal is yet to be published. Stop. In the absence of the CRZ regulation, the same cannot be identified. Stop. Paragraph. Next contention is that the NJT could not have delegated its authority to adjudicate upon a committee. Stop. Paragraph. Further submission is that the cause of action arose long back, and as per the National Green Tribunal Act 2010, the constructions made by the petitioner could not have been directed to be demolished at such a late stage. Stop. Paragraph. The constitution of the NGT in passing the order dated 2nd May 2022 has been challenged. Stop. It has been submitted that any order passed by an authority dehors the provision of law is coram non judice, and no step can be taken in compliance of the same. Paragraph. The matter is yet to be heard. Stop. The parties are to make formal arguments. Stop. As there is an immediate threat of demolition of the construction which are used by the petitioner for running their business. Accordingly, the interim order praying stay of operation of the impugned notice is allowed. Stop. The Impugned notice dated 11th November 2024 shall not be given effect to till 13th of December 2024 or until further order, whichever is earlier. Stop. The respondents are directed to file report with regard to the averments made in the writ petition by 4th of December and serve copy upon the learned advocate representing the petitioner. List the matter on 10th of December.
But shall we submit a reply to the
Prior to that, you can do it. No difficulty. And one more thing. Leave is granted to the advocate on record of the petitioner to implead Vishnupada Pakhira as respondent in the instant writ petition and serve copy of the writ petition upon the added respondent. Affidavits of service filed in court is taken on record. ঠিক আছে?
Deeply obliged, my lords. Grateful.
বইটা ফেরত যাবে।
Both the parties are only for orders.
This book.
And item 3 is the
Item 3. Show me the notice, impugned notice and the stay thereof.
Now please come to page 75, 76. 75.
Now this is 25th of April 24 is a
No,
different
75,
matter.
my lord, 75.
75.
75 and 76.
Wait.
75, the order of NGT is 25th of
My
April
lord, first is
2020.
page 68. My lord, I was misled by Mr. Gali. Kindly see my lord. Page 68. Item 3, 68.
Yes, 2nd May 2022.
And my lord, the subsequent notice.
Subsequent order 25th April 24, where is it?
25th April 20, volume 3 kindly comes. 2024. My lord, volume 3. Are NGT order, Dada. Oof. No, 25th April. My lord, please take the trouble to
25th April is not an order. It's a report.
As per the order of Honorable NGT, wide such and such, dated such and such, and original application such and such, your application, you are requested to attend a hearing at the.
353. My lord, order is dated.
All right. Not annexed.
No. What is not?
25th April, show me please.
My lord, report. My lord, your lordship is looking at page 68.
No, page 75, first line. 25th of April, the date is mentioned. It's a memo.
Yes.
All right. All right. All right.
25th was never served on us. The 9th July is a part of the record. And my lord, this has been communicated. Mail ta kothay? Ye mail jeta pathiyeche ora je ekhon eta
So
hocche
for you, there is no order of demolition.
Yes, of course.
It is there. The
68,
space 68.
68.
This is in respect of all.
Yes.
All stakeholders.
Yes.
And who are you?
I am, my lord, some of the hotels. I am
And
11
are-
number of hotels.
And are those hotels or hoteliers not member of the association?
Yes, they are, of course, members of the association. Some
And
of
why
them
again
are,
is
some of them
separated?
are, not all. Some of them are. In that, I tell your lordship very candidly, before the subsequent proceeding in 2024, which is the suo motu proceedings going on, where the petitioner, despite notice, has chosen to remain unrepresented before the tribunal. My lord, in that matter, the hoteliers, the total group, represented by Mr. Bandopadhyay and my clients, my lord, comprehensive applications were filed, taken on board, my lord, and there is a specific order made by the tribunal in connection with the proceedings, which obliged us to file separate applications. and the matter has been posted for 3rd of December, তাই তো? That order টা দেখো, সেই order টা তো আছে এখানে on record. Now please see that order. That order is 11th of.
No, it is 11th September.
I'm just giving you a lordship, just giving you a lordship. Order to লাগাও না?
The petitioners are aggrieved by the notice dated 11th November 2024 issued by the chairman, district level committee of WBCZMA and district magistrate and collector Purbo Mednipur, directing all stakeholders to demolish and clean the illegal construction within 20th November 2024 in terms of the order passed by the Honorable NGT on 2nd May 2022. Stop. Paragraph. A notice of hearing was issued to the petitioner on 12th November 2024 with a request to attend the hearing on 22nd November 2024. Stop. It has been submitted that the hearing has since been postponed and no fresh date has been intimated to the petitioners. Stop. Next. The court is hearing a similar issue in WPA 27403/2024 within bracket Mondarmoni Hoteliers Association versus Union of India and others. Stop. Next. The court has already granted an interim stay to the impugned notice dated 11th November 2024. Stop. The stay shall apply in case of the petitioners also. Stop. The respondents are directed to file report by the same date. আগেকার ডেটটাই দিয়ে দেবেন. Returnable on the 10th.
Only
Your affidavit of service.
My lord, I have kept it on. My lord, only additionally, I'll be praying for, my lord, prayer M, prayer M and prayer N. My lord, the proceedings in connection with OA 22 of oblique 2024, the suo motu proceedings, my lord, which is fixed on 3rd of December.
You bring the order what is passed over there because 10th the matter is fixed. I'll see what is to be done. What the court will do.
No, 3rd December, they have been directed to report compliance. My lord, please see the previous orders, please see page 358 once.
Report compliance, there is a stay. They
Very
will obviously go and intimate.
We will communicate, my lord,
yes.
Liberty to communicate. And my lord, prayer N also. My lord, Mr.
What is
Bhattacharya,
there?
my lord, they are staying the operation of 2nd May 2022, the original order.
Subsequent order has been stayed.
Very.
জানা বাবু
কোন affidavit there is one leave required,
সেটা কিন্তু আপনি বসবেন.
Leave required to correct, my lord, the number in prayer M. OA 22 হবে.
Leave granted to the advocate on record of the
আর কিছু
petitioners to correct the
পুলিশ না ভাই ঝামেলা পুলিশ না ভাই
case number. Is it the case number?
Yes, yes.
Case number mentioned in prayer M of the writ petition. যেটা যার সেটা তাদের লিখবেন. এটা প্রথমেরটাতে ছিল. প্রথমে writ petitioner affidavit of service পেয়েছেন?
I'm grateful, dear Lord. 10th any time is fixed.
Please come.
My lord, it is not proper to mention a matter, but my lord, my
Then don't mention.
property. My lord, kindly pardon
No, don't
me.
mention.
My lord, pardon me. My lord, properties are being sold on Monday, and my lord, Monday, if what matter can appear urgent motion as a matter of, and Mikash Ranjan Bhattacharya is leading me, he will also not be available for Tuesday onwards. So if
The matter is there in the list.
yes, 23, my lord, urgent motion if on Monday, my lord. Because properties will be sold. That is by urgency. I would not have disturbed your lordship.
Who is your other side?
I will intimate him. I will intimate him by notice that lordship will take up the matter on Monday.
Item 23, put it in the urgent motion bundle. Item 23 of today's list.
I am grateful.
And please call item number 4.
I am grateful.
Only lordship will pass the orders. That's right.
Yes. Item number 4. The court has considered it and has come to an opinion that the petitioners will be eligible to avail the facility of arts and the respondent number 4 has been directed to provide such facility to the petitioners. The order will be put up in the server.
Most obliged, madam.
Grateful.
নামগুলো দিন, নামগুলো দিন। আরেকবার দিন, নামগুলো দিন। নামটা দিন।
Take back your book, please.
My lord.
And the notifications
Lord,
and
the
all
names
should
of
be
the
kept in the
advocate-
record, Lord.
Madam,
The
the name-
notification that I have handed.
Everything is there on record.
My lord, the names of the advocate may be given. My lord.
হয়ে গেছে, আর কি?
Just 1 minute. For the petitioner, Mr. Ochin Jana, Ms. Gargi Dhang, and Mr. Bhaskar Dolui.
My lord, there is one addition, my lord, Miss Chetna Rustagi. My lord,
Oh,
one
there is
addition.
one
If your
addition.
lordship, please.
For the state, Vishwabroto Bosumollik and Debraj Shahu.
Lordship.
For the respondent number 4, Mr. Dhananjay Banerjee, Mr. Suman Chakraborty, and Prosenjit Ghosh.
Obliged, obliged.
So only one name is
Only
to be
one name.
included. Very well. Then you chalo.
I'm handing over the
Send it to my chamber.
obliged.
Grateful.